The Honorable, the Chief Justice and Justices of the Supreme Court of Pennsylvania. Oyez, oyez, oyez. All manner of persons who stand bound by our cognizance or who otherwise have business before this court may now appear and they shall be heard. God save the Commonwealth and this honorable court. Please be seated.
Welcome to the first day of our spring oral argument session here in the Harrisburg courtroom of the Supreme Court of Pennsylvania at our majestic state capitol building. As you may know, the Pennsylvania Supreme Court is the oldest appellate court in North America. Our roots date back to William Penn's Provincial Court of 1684, and our Supreme Court was formally established pursuant to the Pennsylvania Judiciary Act of 1772. In 2022, we celebrated our 300th anniversary with a special session in Philadelphia. We on this bench are very proud of our rich histories. Attorneys who have argued before this court are aware that I like to point out some of the splendid works of art displayed in our magnificent courtrooms. First, as you may have noticed, this courtroom is not in its usual pristine condition. In 2020, we noticed water damage to the intricate plasterwork that adorns the northeast corner behind the bench. Since that time, our Supreme Court Administrator, Chris Nace, and our court crier, Brian Minner, have diligently worked with the Department of General Services and Capital Preservation Committee through its Executive Director, David Craig, to address the water intrusion in what you can imagine is a daunting process in such a historic courtroom. That's one of the reasons why Moses is now on the floor rather than on the wall. Following extensive exterior repairs in 2023 and 2024, our court made the difficult decision to allow conservation specialists to remove damaged surfaces and allow the underlying masonry to dry. While we are optimistic that the exterior work resolved the issue, additional efforts may be necessary to prevent water from intruding into this beautiful space, and our court administration will continue to work diligently to restore this artistic treasure of the Commonwealth to its original grandeur. As architect Joseph Houston envisioned this building to be a palace of art, I highly encourage everyone in attendance to visit the rotunda, legislative chambers, and governor's reception room with an eye toward the beautifully created artwork, particularly the famous Violet Oakley murals installed in 1927. Over the past 26 years, I've had the privilege of sitting in this courtroom on this bench to see the majesty of these beautiful murals by Violet Oakley, a woman of incredible talent and vision. What a treasure this confluence of history and art provides to the people of our Commonwealth. The Capitol Murals Project was the largest commission ever awarded to an American woman. Remarkably, Violet Oakley, a young Philadelphia artist, was selected for this daunting assignment at a time when women could neither vote nor hold elective office. On May 23, 1927, the Supreme Court of Pennsylvania convened to unveil the majestic Violet Oakley murals that you see around you. Ms. Oakley was selected by the Capitol's architect, Alfred Houston, in the hopes that providing such an opportunity might inspire other women to pursue art. At the time, such a commission was a radical concept, and she was the first female artist ever to receive a large public commission. Ms. Oakley proved to be up to the task. Already a well-regarded artist from Philadelphia, Oakley's work in this building made her world-renowned. Ultimately, she devoted 25 years of her life, from 1902 to 1927, to painting 43 murals in our capital. I trust that no one who works here takes this gift for granted. While there might be many things that our three branches of government disagree on, I know that our judiciary, along with legislative and executive branches, all agree that we have been blessed with the privilege of serving the Commonwealth and that our lives are enriched by the beauty of these inspirational murals in our magnificent capital. Before we hear the first case, I would like to remind counsel of a few things. Appellant's counsel, please approach the podium when your case is called. I will then give a short summary of the case. Please begin by introducing yourself and your co-counsel and identifying the party you represent. The justices are familiar with your cases, so we ask that you avoid any unnecessary recitation of facts or procedural history and instead focus on the main issues on which we granted review. Counsel is welcome to rely on their briefs for any particular issues. In cases where there are multiple parties represented by separate counsel, counsel should avoid repeating the same arguments as prior counsel. Please do not interrupt the justices when we are asking you a question. A justice's question is not meant to trip you up. Rather, it indicates that there are particular issues we wish to explore further. I remind you that we do not allow rebuttal. Finally, while we have no set time limit for argument, I will advise counsel when the court is satisfied that all of its questions have been answered, and at that time I will ask that you conclude your argument. Mr. Minner, please call the first case.
Cleveland Brothers Equipment Company versus Arcadia and Blue Rock Construction, representing Cleveland Brothers, Alicia Schmidt, representing Blue Rock Construction, is ready to apply.
Good morning. In this appeal by allowance, we are asked to determine whether the mechanic's lien law authorizes a lien against an owner's property for unpaid rental charges related to the use of construction equipment, specifically an excavator, used for excavation, grading, and other preparation work on the property during the development of an industrial park. Please proceed.
Thank you, Your Honor. Thank you, Chief Justice Todd and all the honorable justices of this court. May it please the court, my name is Alicia Schmidt and I represent Cleveland Brothers Equipment Company in this matter. This case involves the construction of a statute, the Pennsylvania Mechanics Lien Law of 1963, as it's been amended and as it exists today. The matter calls upon the court to interpret certain language within our lien law, which we believe is clear and unambiguous. There are 4 sections of the law that we believe are particularly relevant, which has been addressed in the briefing. The first section of the lien law is section 1301A, which is it's not the first lien law, but rather the one that we would like the court to consider first, and it creates the general right to lien. In relevant part, that statute provides that every improvement and the estate or title of the owner in the property shall be subject to a lien for the payment of all debts due to the contractor or subcontractors for labor or materials furnished in the erection or construction or alteration or repair of the improvement. And the next 3 sections that I'd like to discuss define several of the terms in that section that I just read, section 1301. The terms that I think are important to define here for this case are subcontractor, erection, construction, alteration, or repair, and materials. And in short, our argument is that Cleveland Brothers was a subcontractor that furnished materials for the erection or construction of the industrial park. That's the real property at issue in this case. Specifically, Cleveland Brothers, as the court noted, furnished a heavy equipment excavator that was used to excavate the site as needed for the construction of the industrial park. And in this case, there's no real dispute that Cleveland Brothers is a subcontractor. The Superior Court acknowledged that Cleveland Brothers was a subcontractor, and that's significant because under section 12015, the definition of subcontractor, it includes one who, by contract with a contractor or another subcontractor, erects, constructs, alters, or repairs an improvement or any part thereof, or furnishes labor, or supplies or hauls materials, fixtures, machinery, or equipment reasonably necessary for and actually used therein.
So here Cleveland Brothers was the subcontractor to a subcontractor?
Yes, Your Honor. And in this case, Cleveland Brothers contracted with another subcontractor, which in this case was Dobrinsky Brothers, who was a subcontractor to the general contractor, Blue Rock, who worked for Arcadia, the property owner. But Cleveland Brothers contracted to supply or haul materials, machinery, or equipment, and that language is from the definition I just read, i.e., the excavator that was reasonably necessary and actually used in constructing the industrial park. And as the trial court ruled as a matter of fact, and it's not disputed here, the excavator was reasonably necessary and actually used. It was used for 10 months and over 600 hours. The GPS data shows that it was over the site during that period, and the trial court ruled that as a matter of fact, it was integrally necessary for the construction of the industrial park, which was ultimately constructed upon the excavation done by the excavator. Next, the next section we would like to look at is 120112, which is the definition for erection, construction, alteration, or repair. And we merely want to note that that section explicitly includes excavation, grading, and filling performed incidental to the construction of an improvement within the term erection, construction, alteration, or repair. So any place you hear erection, construction, alteration, or repair, you can fill in excavation, and those terms should be synonymous. And therefore, that definition clearly covers the work done by the excavator. Excavation is done by an excavator, so that work is clearly included. Finally, and then this is the definition that the trial court, I'm sorry, not the trial court, the Superior Court focused on, was section 12017, which is the definition for materials. And I'd like to focus on the central portion, the core of that definition, which is not what the Superior Court did, and we can obviously get to that in a minute, but the core of that definition defines materials as building materials and supplies of all kinds. And we believe that the excavator clearly falls within that definition because building materials and supplies of all kinds, while it is broad, it's not ambiguous.
Well, isn't machinery and equipment in the next line, isn't that a lot more akin to what an excavator is than materials and supplies?
So machinery and equipment is included in the next part, but that next part, which is, and we can get to it now, materials also includes machinery and equipment that is incorporated therein, and that's the part Your Honor is referring to. That and also includes language is necessarily adding to the first part of the definition. It can't take anything away from it. And that's, common statutory construction and common usage of the language. So just because that word equipment appears in that section, it can't take away the fact that it doesn't mean that that's necessarily the section that applies. The section that applies...
It helped you, I'm sorry.
Oh, go ahead.
I'm missing that point. I thought the second part of 12017 actually helped you. Did I miss something there?
So our position is that the first section is the more applicable section. We believe that we can also fit into the second part of the section, but we don't believe that that's the most natural reading of the statute.
You prefer the first section because you want to avoid the incorporated into, which is really the meat of the case. The question is, the real meat of the case isn't the real meat of the case whether you fit the incorporated into the improvement. Isn't that where the real debate is here?
We don't believe so. That is certainly where the Superior Court focused, but we don't believe that that's the correct interpretation of the statute, the natural reading of that section. And I have an analogy, I think, that may be helpful, because I was, so the statute itself reads, materials means building materials and supplies of all kinds and also includes fixtures, machinery, and equipment reasonably necessary to and incorporated into the improvement. And an analogy that I think may be useful is if, you imagine a new restaurant came to town and it's a dessert restaurant. It says, we're going to sell desserts and sweets of all kinds. And our menu also includes savory pies and pastries. And I say to my friend, I'm so excited to go to that restaurant. I really would like, probably an apple pie would be great, or a blueberry pie, or maybe a Danish. If your friend turned to you and said, they won't sell that there because it says savory pies and pastries, so they won't have sweet pies and pastries. That's nonsensical. I think we can all agree that that doesn't make any sense. And just so here, because we fit into the first section, it's tempting to just look at that second part and it's like, well, it said the word pies, so pies, that second section must cover the whole universe of pies. But that's not correct in an analogy, and I think that that's not correct here.
If you are correct, wouldn't the legislature have written including without limitation instead of using the word also? Because when we read the word also, aren't we being signaled there's this other thing?
I do agree, and that's where the analogy comes in, because while a different thing is involved in the second section, it doesn't take away from the first section. And I think it may help to indicate, so here's what I think the second half means, okay? And I think this may answer the question. When it says building materials and supplies of all kinds, that means just what it says. And then it says, and also includes fixtures, machinery, and equipment. I believe that second part is meant to include things that are not just fixtures, but things that are in the nature of fixtures, which may not meet the definition. Well, what's the definition of fixtures? It's things that are physically attached to a building, and this is cited in our briefing by Noel v. Harrisburg.
You'd have a better argument if that last and was an or, I guess.
I'm sorry, which last and?
Paragraph 7, you would have a better argument if it was an or rather than and incorporated into the improvement.
And equipment reasonably necessary. So I think if this part of the statute is ambiguous, then maybe it is useful to look at useful to look at the comment. And the comment to that section, 12017, says the Act of 1901 contained no express definition of materials. This definition follows existing law, which used the phrase reasonably necessary for and actually used therein. But then, and this is not included in the briefing, but I do think it's important, the enumeration of the types of fixtures subject to lien contained in Section 2, Act 1901 is omitted as unnecessary. And I think that what they're doing with that second half of the definition is omitting the long list of fixtures and other things that were similar to fixtures as unnecessary. And I do have that section of the.
But counsel, before you go there, I'm not following your construction of the first part of the definition of materials means building materials and supplies of all kinds.
Yes, Your Honor.
If you're saying that's a broad, all-encompassing thing. To include machinery and equipment.
Exactly.
Right? If that's true and it's so broad and encompassing, why did the General Assembly do the and also? Because it seems to me that everything that comes after the and also would fit what you believe is a broad, definitional phrase, building materials and supplies of all kinds. So why the additional and also, if it's as broad as you say it is?
I think it is to cover, the list of fixtures and fixture-like things that was taken from the 1901 statute.
But your argument is premised on the idea that the first clause is all-encompassing. So you're saying it's basically surplusage.
I don't believe it's surplusage. I think that it's meant as clarification language, and it's meant to ensure that those words are not limited unnecessarily.
Well, that would be, to Justice Weck's point, then it would be including but not limited to. It wouldn't be and also. And also, I'm following your argument from the jump. Your argument from the jump was there's this broad term, which is what we're relying on, which includes our stuff. And then there's this and also thing that we don't necessarily fall under. But the problem you have, that I'm struggling with, is your and also fits under your broad definition as well. So I'm trying to discern the General Assembly's intent here. If this statute ended means building materials and supplies of all kinds, period, everything that follows the and also would arguably be in there, as would your stuff. But it's the and also language that cuts against your point that everything before and also is all-encompassing. You see what I'm saying?
I do see what you're saying, Your Honor, but I think, first of all, I go back to the point that the and also includes can't limit. It must only add to, because that is the nature of that language.
Well, that's, I mean, just to follow up, taking your point that it adds to, so the legislature said machinery and equipment. And doesn't an excavator look a whole lot more like machinery and equipment than materials and supplies?
I don't think so, Your Honor, and I would go to that just to the plain common usage of the words material and supplies, and we've cited, the Oxford English Dictionary and Merriam-Webster in our brief, and I think that is what is the most relevant here. For example, the dictionary definitions talk about supplies and material frequently being used with a distinguishing word such as cleaning or writing, or in this case, building. And so a writing material is not just, for example, is not just the ink that's inside the pen. It's the pen itself. It's the apparatus used to do the writing. And likewise, a building material or building supply is not just the thing that's used inside the building, but the apparatus used to do the building.
But we have to assume everything after the and also does not fall within the first clause.
I would agree with that.
Right. So machinery and equipment does not fall in the first clause.
But I think that's like my pie analogy. Just because savory pies and pastries is used in the second half doesn't mean that sweet pies and pastries is not included in the first half, even though the word pies is used in the first half.
So you're saying machinery and equipment of your client's type is included in materials and supplies, but machinery and equipment reasonably necessary to and incorporated into the improvement is not a material and supply.
So I think the most natural reading of that second half of the thing is,
Before you go to the natural reading,
Yeah.
that's what I'm trying to understand. I'm trying to follow your argument. You're saying materials and supplies in the first clause includes your client's excavator,
correct.
but it does not include another piece of machinery and equipment necessary to and incorporated into the improvement. That is not a building material or supply.
I mean, our argument is, as a fallback, we can fit under that definition, but no, I think.
Don't do your
Yeah.
I want to know what how do you respond to that? That for you're saying building material and supplies includes your client's excavator, but does not include any other type of machinery and equipment reasonably necessary to and incorporated into the improvement.
So I think that as the statute is drafted, a fixture was considered different from a building material or supply. And there was a long list of fixtures and things that were like fixtures.
This isn't just, I'm not talking about the fixture part, I'm talking about machinery and equipment.
So
Machinery and equipment, so you're saying machinery and equipment that isn't a fixture or doesn't become a fixture is a material and supply, but if the machinery and equipment does become a fixture, it is not a material and supply, it falls within the second clause.
So what I'm saying falls under the second clause, and this language comes from the 1901 statute, is the fitting up or equipment of a real property for the purpose for which the improvement is made. And so that included things like chandeliers in Section 249 PS 21 of the 1901 statute, but it also included machinery, gearing, boilers, engines, cars, or other useful appliances. And so I think what the court was doing, what the assembly was doing there was saying, look, some of these things are going to be fixtures because they're permanently affixed to a structure. Some of these things, while they're necessary for fitting up and the property for the purpose for which it was intended, are not necessarily going to be fixtures because boilers, engines, cars, a car, and imagine, say, for example, a coal mine. The track that the coal car runs on, is permanently fixed to the property. The coal car is not. It's movable. However, that was included in the original statute.
But that stuff that you're talking about, for you to prevail, are not building materials and supplies.
I think that that's a fair statement, or they wanted to be sure at least that if they weren't considered building materials, they were nevertheless not excluded from what could be the subject of a lien. Our position is that it simply renders the lien law absurd that if an excavator that was actually used to excavate the improvement is not considered an excavation material or supply, then it's hard to fathom what would be considered
Well, it would be
an
more
excavation.
absurd to say that an excavator is not machinery and equipment, wouldn't it?
And,
Wouldn't
we're
that be
not,
more absurd?
we're certainly not saying that. Of course,
Well,
it's,
then is it the real ground where this battle is joined is whether it's incorporated into the improvement? Because I thought part of your brief is arguing that it's incorporated into the improvement even without being physically left there.
we do think that the language incorporated into the improvement is certainly broad enough to include things that are not permanently physically attached. And that is what the trial court held. The trial court held that it was incorporated into the improvement by means of the fact that it was integrally necessary for the construction of the foundation, and without that, the building couldn't have been built. You can't take the foundation out. You can't take the grading and excavation out. It's a permanent part of the improvement, and therefore it's been incorporated into, and that is what the trial court held.
So, counsel, you're reading this as to distinguish between things that are incorporated into the building and things that are not incorporated into the building. So, as the statute reads, the first phrase would apply to those things that are not incorporated into the building, and the second
improvement.
into the improvement, and the second phrase says, and it also includes equipment and machinery that become part of the improvement.
So no, Your Honor. To clarify, we are saying that the first part includes building materials and supplies of all kinds. So that would be the kinds that are incorporated into it, that are made a physical permanent part, and the kinds that are not made a physical permanent part. And that includes things like, the court held in BN excavating, temporary risers and spillways, things that are temporarily used in the construction that are reasonably necessary and actually used for the construction, but do not become a permanent part of the property.
Well, why isn't that included in the first part? I don't understand why the distinction that you're making there. What you just described are materials and supplies that are not incorporated into the building. You would want to fall into that category, would you not?
Yes, Your Honor. I'm not sure I understand the question. So we're saying that the first part of the definition includes things that both are and are not made a permanent physical part of the structure.
Why would that be? Then what's the point of the second part? Why do you have to distinguish that which is not made a part of the building if it is included in the first clause?
I don't think that the second part distinguishes things that are not made a part of the building. I think that it adds to building materials and supplies of all kind, fixtures and things in the nature of fixtures that are used to fit up and equip the building for the purpose for which it was constructed.
All right, I think we understand your argument.
Chief, could I ask counsel one more
surely.
question? Your opposing counsel says that you had other remedies. You could have sued Dobrinsky Brothers, who were the real villains. You could have sued them in contract, in conversion, or under the Contractor and Subcontractor Payment Act. But you didn't do those things. So, or you could have, I guess, insured against these risks. So how would you respond to those arguments that they make?
So in fact, we did file that suit. We have a suit that's currently stayed in the Allegheny County that is a breach of contract action against Dobrinsky Brothers and quantum merit and unjust enrichment against the property owner and against Blue Rock. However, as Blue Rock is well aware, Dobrinsky Brothers is liquidated. There's no possible recovery against them. And that is, in fact, one of the things, so we have, we've moved for a default judgment, but it's not worth anything. We've not gotten a default judgment yet. They never appeared in court. They didn't show up. The mechanics lien law is meant to avoid having to go after a property owner in quantum merit for the benefit received from the prepayment investment of materials and labor that a contractor or subcontractor puts into the improvement of a property. That's exactly what Cleveland Brothers did here. 10 months of use of a machine, 600 hours of wear and tear on a machine that benefited their property, and the Cleveland Brothers has never been paid for. And the statute is written specifically to protect that class of contractors and subcontractors. And if Cleveland Brothers meets the definition of subcontractors, as the Superior Court acknowledged that we did, then it makes no sense. It's not a plain language reading of the statute to say that we have created a remedy for you. You're within the special class of parties that we believe is entitled to this remedy, and yet you're precluded from getting any kind of remedy for the only thing that you do, an excavator for excavation for the improvement of a property. It's just, so we did do that, Your Honor, but it undermines the whole purpose of the statute.
All right, thank you, Attorney Schmidt. Let's hear from your opposing counsel. Mr. Klein?
Madam Chief Justice, Justices, may it please the Court, my name is Andrew Klein and I represent the Aplt Blue Rock Construction, Inc. With me today is David Scotti, who represents the owner of the property, Arcadia North Land, LLC. In this appeal, the Court asked a single question: whether or not the lien law authorizes a lien for the charges for the use of construction equipment that was reasonably necessary and actually used for the improvement. In addressing that question today, I'll demonstrate that every aspect of the lien law consistently points to only one answer to that question: no. And I'll show that by discussing the definition of materials, the legislative history of that definition, this Court's construction, the way this Court construed that term, the structure of the lien law, the manner in which lien laws claims are enforced or judgments are enforced, and also the current pending amendment that the legislature is considering.
How can you do all that before dinner time?
I'm pretty confident I can do it. The threshold question really is, or one of the two threshold questions is, whether a commercial excavator constitutes material subject to a mechanics lien claim. And the place to start, of course, is the definition of materials. Happily, the legislature defined that term, and it establishes exactly two categories of materials: building materials and supplies of all kinds, and fixtures, machinery, and equipment that are reasonably necessary to and incorporated into the building. With respect to the first one...
Into the improvement.
Into the improvement, I'm sorry. Thank you. Thank you, Your Honor. With respect to the former, building materials and supplies of all kinds, the Statutory Construction Act, as it often is very helpful. It says two things that are particularly important: that we have to construe terms by their common usage, and when general words are preceded by particular words, you have to restrict the meaning by that particular word. And the preceding particular word here is building. So in that first part of the definition, we have to decide what is the common usage of building materials and building supplies. Building materials are things like lumber, brick, steel, drywall, and glass. Building supplies are things like nails, screws, rivets, adhesive. And the commonality and the common usage of those terms, building materials and building supplies, are things that actually become part of the finished improvement, that are embedded in the improvement. Hammers, screwdrivers, shovels, and commercial excavators are not building materials or building supplies. An excavator is equipment. Nonetheless, Cleveland Brothers argues that a commercial excavator is a building supply, and in preparing for today's argument, I was thinking, how's that term used in other contexts? Medical supplies are things like Band-Aids, syringes, surgical masks, and gloves. A $20 million MRI machine is not a medical supply in its common usage. It's medical equipment. Office supplies are paper, pens, paper clips, and staples. A $100,000 commercial printing machine is not an office supply, it's office equipment. And a commercial excavator is not a building supply, it's construction equipment. And I think to underscore that point, the legislature, to Justice Weck's point, added the second half of the definition and said, and also includes fixtures, machinery, and equipment reasonably necessary to and incorporated into the improvement. In so doing, the legislature made clear that there was only one type of equipment that you could lien for, and that's equipment that actually finds its way into the building. Examples that the Superior Court and courts have found are commercial HVAC units that are attached to buildings.
Parsing of the definition, you, as a matter of course, would exclude forklifts, cranes, excavators, backhoes, scaffolding, lifts, bulldozers, anything that a contractor typically relies on in the construction of small and even large construction projects. And how much sense does that really make?
Well, I think it makes sense in many different ways. And to answer your question directly, yes, I think it does. The mechanics lien law does exclude those sorts of things. The lien law is it's not intended to make somebody that does any work on a construction project whole. The lien law, as this court said, is an extraordinary remedy.
Well, isn't the point of the mechanics lien law to not allow owners of properties to profit on the backside of subcontractors who sweated and toiled to build those properties?
I would say that's certainly one of the reasons for the mechanics lien law. But it's not always the case that owners profit from the sweat of those parties. In cases like this one, for example, it's undisputed that both Blue Rock and Arcadia paid in full under the Dobrinsky brothers contract. But what the lien law does is it says we're not going to make everyone whole. We're going to compensate them for the materials and the labor that they used in constructing the improvement. It does not include things like the equipment and the shovels that they carry. And I think that the legislative history of the statute and the definition of materials is very helpful. We don't have to guess at the legislature's intent. It told us what its intent was. It said in its official comment, the Act of 1901 contained no express definition of materials. This definition, the one that we're discussing today, follows existing law, which used the phrase reasonably necessary for and actually used therein.
Well, I guess my problem with your, I'll say, parsing of the definition of materials is that when I do statutory construction, when I read a phrase that says of all kinds, I read that as a very inclusive phrase. I'm also read and also includes as more of an inclusive phrase as opposed to a limiting phrase. And so that's kind of where I'm hung up with.
Yeah, I would say under either half of the definition, in order to be lienable, it has to be incorporated into the improvement physically. The Statutory Construction Act also says that when a court of last resort, this court, has construed the language used in a statute, the General Assembly and subsequent statutes on the same subject matter intends the same construction to be placed on the language. And how has this court construed the definition of the word materials in the lien law context? And that was in the Hoffman case, and that was under the 1901 Act that the comment it talks about.
Counselor, can I interrupt real quick?
Sure.
When were excavators invented?
I have no idea.
You're quoting language from 1901, which I understand because it benefits your argument, but the fact of the matter is excavators, cranes, these types of equipments that we're dealing with now weren't even around in 1901 at the time these definitions. And I keep coming back to what Justice Mundy just asked you about, which was in the good old days or the bad old days, when you were trying to level a piece of property. In other words, you would have men out there with pickaxes, shovels, doing the work. Under this particular issue, that particular work would have been lienable, would it not?
The labor of doing the work is lienable, but not the cost of the shovels that those people were carrying.
We're talking about the labor itself.
Yeah, the labor is lienable, no matter what that labor is. If it's involved in the improvement, you can lien for it, but not for the tools. And that's what while a commercial excavator might not have been invented at the time of the Hoffman case, shovels and other implements and appliances used for construction were. And this court specifically said that in order to constitute material subject to a lien claim, the material must become part of the physical permanent structure. And equally importantly to Hoffman, Hoffman held that lumber for temporary scaffolding.
You keep coming back to that definition, but the fact of the matter is, when you're talking about excavating, you're talking about somebody who is an excavating company. So your contractor is actually subcontracting with an excavation company to provide manpower and somebody to operate the excavator, to actually do this particular land clearing itself, to create the pad, to do the compression of the pad. Everything else is then literally and figuratively built upon the work of the excavator. So under your definition, if I hire an excavator, an excavating company, to rent their particular manpower and their excavator, why isn't it covered?
Well, what's covered would be the labor.
How do we bifurcate that between, how do you know it's not the labor you're hiring as opposed to the person that actually worked the excavator?
Well, you couldn't charge for or recover under a lien claim for the cost of the excavator, only for the labor. I mean, that's the way that the lien law structured lien claims. And if you think about the way that lien claims are enforced, it helps make sense of all of this, because viewing the statute as a whole, lien claims are not enforced when a judgment on lien claim as a monetary judgment against the owner. They're enforced against the improvement itself, so that if the owner doesn't voluntarily pay, the only way to enforce that is by a sheriff's sale. And if you think about that, it makes sense that only things that are physically embedded in the improvement itself, the lumber, the nails, the bricks, an HVAC unit, they make up the value of the property.
That's my point. Where do you draw the line?
We draw the line at where the legislature drew the line, and this court's definition of materials, anything that's any physical item that is incorporated into the improvement is lienable.
What is incorporated into the improvement? I mean, because when you're talking about excavating, you're necessarily talking about the structure is actually built on the work of the excavator. What about infrastructure? In other words, you've got a structure itself that's built on top of a pad that the excavator actually builds. What about the plumbing, the electric, all of the other lines that go from the structure to the actual public utilities? Is that included? Or
all of those things are included because they fall under the definition of materials. They're a material. The conduit, the plumbing, the wires.
They're not in the structure, is my point.
But they're part of the improvement. I mean, a physical part of the improvement.
The pad site's not part of the improvement. The pad site is not part of the improvement.
The pad site is part of the improvement, but the only lienable part of the improvement are things that are physically attached to it. Like this. Sure.
Are you basing that upon the Hoffman case of 1923?
I'm basing that in part on the Hoffman case of 1923. Excuse me, I'm sorry.
What other part are you basing that on?
I'm also basing it on the structure of the lien law as a whole. In every place where the lien law talks about what you can lien for, it uses some form of the preposition in and not for. For example, in the definition of subcontractor, the legislature described an entity that hauls machinery, fixtures, machinery or equipment reasonably necessary and used therein. And counsel mentioned that there's no dispute that Cleveland Brothers is a subcontractor. We dispute that Cleveland Brothers is a subcontractor because Cleveland Brothers did not haul something that was ultimately incorporated into the improvement. In identifying the right to lien, the legislature granted that right for labor and materials furnished in the construction, not for. Even in the statutory presumption regarding the use of materials, the legislature presumed that if they were placed in or near the property, it presumed that they were ultimately used therein. The prepositions in, into, and therein have a consistent meaning under the lien law. It means that it's physically inside the improvement, not.
So so I mean, I understand where the questioning has come from in the sense that, there's a distinction here between buildings and improvements. A building is an improvement, but not all improvements are buildings or structures. So the thing that I think makes this case a little bit difficult is an improvement can be a clearing. It can be a leveling. It can be, and that adds value to a piece of dirt that is not buildable. Creating a buildable surface purely by the use of an excavator adds value to property. And why, in the response I think you're going to give is because that's what the General Assembly did. But I guess the question is why, if an excavator is the implement to improve the value of the property for the developer, why is the cost of that excavator not lienable?
I'd say I have three answers to that question. The first answer is that
the labor would be lienable. It's just why isn't the equipment lienable?
The legislature the General Assembly drew the line somewhere. I mean, it said that you can't lien for everything, or they would have said in the lien law, you can file a lien for the cost of construction. And in fact, there is a definition for the cost of construction in the lien law that is extraordinarily broad, that all costs and expenses pertaining to the erection, construction, alterations, and repairs. But that's not how the legislature defined what you could lien for. That was used subsequently in a priority thing regarding the priority with other types of judgments. So the legislature knew how to be more expansive than and could have been more expansive. So that's the first reason, because the legislature said so. Also, entities like Cleveland Brothers are not without remedies. Pre-contractual remedies, an entity like Cleveland Brothers could certainly have required prepayment for the excavating equipment, like commercial movers do, like criminal defense lawyers do. They have safeguards that they could put in place. They could request that a payment bond be involved in the project that would ensure that they would receive payment. And the third reason really is that this court has said specifically that you can't lien for like temporary scaffolding and structures and things that are used in order to create the value in the property. That was one of the pieces in the Hoffman case. So if there was a whole bunch of lumber and other materials that were, and I'm using materials in quotes, other sorts of materials that were brought to the site in order to help develop the property, that wouldn't be lienable under Hoffman. It wouldn't be lienable under the mechanics lien law, because those materials were taken away and not ultimately incorporated into the final improvement.
What about the erosion and sediment control things that are isn't there, was that Hoffman, or is there another case that talks about those being lienable?
I don't think there's any case that specifically talks about what materials may be lienable in a excavation case. There's the BN case in which the Superior Court, it involved excavating, but it never reached the decision as to what materials could be lienable, or what constitutes materials that could be lienable. In that case, the trial court ruled that because there was ultimately no building that was constructed, that
involved like erosion and sediment control
Yep.
measures and things like that as well. But you're under your theory of the case, those erosion and sediment control measures that are temporary would not be lienable.
Exactly. That's it. And I think to Chief Justice Todd's point, the General Assembly is currently considering an amendment to the definition of materials. And I think that's really helpful in two ways. The proposed amended definition is building materials and supplies of all kinds, currently in the statute, and also includes fixtures, machinery, and equipment. And here's the new language: including rented equipment reasonably necessary for the construction of or incorporated into the improvement. So the General So the General Assembly recognized that the way the statute's currently written, it's an and it's not an or.
Can I ask you a question?
Of course.
Following up, counsel. the General Assembly did not write physically incorporate into. They wrote incorporate into. So it raises the question for me of whether it can be read to mean used in. Like you mobilize all this equipment, you got an excavator, you got this piece, you got that, and there's this big job to build maybe a suburban shopping center, with the terraced walls and everything. Is it fair to say that all of that equipment is incorporated into the improvement such that it would be lienable, not physically incorporated, but it's used in? Think of it this way: if I'm writing an opinion and you submit a memo that I find really helpful, I incorporate it into my opinion, but I didn't physically cram it in there, but I incorporated it into my opinion. Why shouldn't we read the statute that way?
And I'd say that the Statutory Construction Act says that when this court has construed a term in a prior statute, the General Assembly intends that the same construction is going to be used. And in fact, the General Assembly specifically said the Act of 1901 contained no express definition of materials. This definition follows existing law. And the existing law was this court's decision in Hoffman, where this court ruled that in order to be lienable, a material must become part of the permanent structure. That it's no more lienable to have to lien for temporary scaffolding than it is the tools and appliances, the equipment that a contractor uses to actually construct the improvement. That's the point of the lien law: physical incorporation and not everything that's helpful. Because to your point, the lien law specifically says you can't lien for engineers and architect services. That's certainly an architect's and an engineer's grading and design work. That certainly helps, obviously, instruct and develop the improvement, but you can't lien for that. It's only the labor, the skill in superintendents, and the physical materials that find their way into the structure that can be liened for. And the legislature is attempting to address that now.
And the machinery and equipment that would be incorporated into a structure, you mentioned HVAC system?
Yes.
Anything else you could think of?
Yeah, a commercial refrigeration unit in a supermarket, that would become a permanent part of the structure. Those are the two clearest examples that I can think of.
Generator? Emergency generator?
That would do it also, yes. And that's why they added that second half to the definition, to make clear that the only equipment that could be liened for is the stuff that ultimately becomes attached to the property.
Counsel, if I might.
Sure.
Why add the phrase "of all kinds"?
It's just so that it's not limited in any type of actual building material and supplies.
Why would it be limited without that? It says means building materials and supplies. Why would that be limited if the phrase "of all kinds" is not added to the end of it?
It's just to say that the variety of building materials, that all building materials, wood, brick, steel, glass, drywall.
But that would be a building material or supply.
Yes, and that's to say
without saying "of all kinds." Doesn't "of all kinds" means that it's expanding an otherwise traditional meaning?
Yeah, it's saying that in anything that qualifies as a building material or supply is covered by the lien law.
And that's what it would say even if it didn't add the phrase "of all kinds." There are no words of limitation.
That's true. That's true. I think they were just trying to make...
Doesn't "of all kinds" mean broadening the concept of building materials?
I think it's just the words to make clear that they're not intending to be limited to any particular category of building materials or supplies.
Which it already said, so it's kind of belt and suspenders.
Yes. Yes.
All right.
And I'd say that in closing, if there's any doubt in any of your minds regarding whether or not an excavator constitutes a material, I'll refer back to this court's decision in terra firma, and really every decision that this court's ever made in a mechanics lien case. It said that the lien law is a creature in derogation of the common law, and any questions of interpretation shall be resolved in favor of a strict, narrow construction. And in this case, the word narrow is what I want to highlight. The lien law isn't designed to create and compensate everyone for every dollar that's spent on a project.
Can I ask you a question on that,
Sure.
Counsel? You mentioned prepayment bond. How often in your experience is that done?
It depends. I'd say in larger projects, it's not uncommon.
So like at a job like this, would it, in your experience, would it be customary for a firm like Cleveland Brothers to get other kind of security in advance?
They could certainly request that security be provided. In fairness, a lot of times owners and general contractors don't want to incur the expense of a payment bond, so it doesn't happen in every case. It's very hard to pin down when it does happen, but I've always thought it's a very good idea if you're working on a project to work on one with a payment bond, because then you know that regardless of what happens on a project, you're going to be compensated.
I'd rather work on that project.
Yes.
All right, we understand your argument. Thank you both very much.
Thank you.
Mr. Minner, would you call the next case?
Commonwealth of Pennsylvania versus Charles
Sure, case, fine.
Adams, representing Mr. Adams, and Matthew Volkovich, representing the Commonwealth of Mississippi.
Interesting issue.
In this appeal by allowance, we are asked to determine whether the trial court erred in permitting the Commonwealth to present expert testimony, even though it did not notify the defense of its intent to call the expert witness until mid-trial. In conjunction with this question, we must consider whether appellant has demonstrated that he suffered prejudice as a result of the Commonwealth's actions, and if so, what the appropriate remedy should be. Please proceed.
Madam Chief Justice, Justices, good morning. May it please the Court. Matthew Volkovich, Chief Deputy Public Defender for Lycoming County on behalf of the appellant Charles Adams. At the heart of this appeal is Mr. Adams' right to have a fair trial by the court allowing the Commonwealth to qualify the child's guidance counselor as an expert under Section 5920 without any advance notice. He was denied that right. As Justice Mundy noted in her opinion in support of affirmance in Dunn, trial by ambush is contrary to the spirit and letter of the rules of discovery. By allowing the testimony despite the flagrant discovery violation, the trial court committed a significant error warranting a new trial, a conclusion it came to on its own in its opinion on Mr. Adams's post-sentence motions. All 6 justices participating in the Dunn opinion found a discovery violation under 573 when the Commonwealth waited until the night before trial to inform counsel of their intent to call an expert under 5920, providing at that time a CV and a bullet-pointed email covering generally what the testimony would include. There was none of that here. There was no report, no CV, no notice. It was done in trial after jeopardy had attached.
Didn't the Commonwealth claim that they had provided the report to prior counsel?
Yes, so that was a claim made during post-sentence motions so Mr. Adams initially had private counsel at the beginning, and the Commonwealth had filed a motion for testimony by alternative means. As part of that, the Commonwealth said that they shared at least a brief statement by this guidance counselor as to why it would cause a substantial emotional distress for the child to testify in front of Mr. Adams, as well as a CV. That was brought up in the post-sentence motion, and in the post-sentence opinion, the motion on the the opinion on the post-sentence motions, the judge mentioned that it asked the Commonwealth to provide that. It has never been provided. And in any event, it was never provided to the trial counsel once he took the case.
What was never provided?
I'm sorry,
Sorry, what was never provided? You said it was a pretrial motion?
a post-sentence motion. Oh, for when they would have received any information on this guidance counselor?
You just said the Commonwealth said that they filed a motion, a pretrial motion to allow alternative, what was it again?
Yes, they had filed that prior to the preliminary hearing.
What did they file?
So that would have been well before the preliminary.
No, you're not, what? Specifically, what was the motion?
It was a motion to allow the child to testify via video.
And in that motion, they've referenced that the guidance counselor would be testifying?
In that motion, they mentioned, or in that motion, they simply stated the language of the statute that it would cause the child substantial emotional distress to testify.
I understand that.
But as part of that, they claim they discovered to original counsel a brief statement by this guidance counselor as well as their.
Was that anywhere in the motion, is what I'm trying to get at?
Not to my knowledge.
Was the name of this counselor anywhere in the pretrial motion? Was there any kind of indication? In other words, if I take over the case from you,
Yes,
and I'm taking a look at the docket entries, the first thing I'm going to look at is all the motions that were filed beforehand, right?
correct.
Prepare myself to find out what the status of the case is. Anywhere in any of those pretrial motions, did it mention this guidance counselor and that we're going to call this guidance counselor?
Not to my knowledge.
She wasn't listed as a witness for trial?
We did not have the transcript from the jury selection. So there was no other emails or anything along those lines to indicate that this guidance counselor was going to be a witness. In fact, the guidance counselor herself does not appear in the entirety of the police report.
Was not in the witness list. Her name was not in the witness list?
Not in it, as I stated, there was no transcript of the jury selection, so I don't know if the Commonwealth mentioned her in the jury selection at all.
Was there a list of potential witnesses provided to the trial judge prior to trial?
No formal witness list provided that I've seen in the record.
You didn't try the case?
I did not.
Counsel, can I go to the objection, though, because I'm looking at the objection that was raised at trial.
Yes.
The objection to trial was a strenuous objection from the fact that they did not receive an expert report. I did not find an objection to a lack of notice. I see an objection to the lack of an expert report, which the trial judge addressed and allowed the testimony in the absence of an expert report. Where was the objection to we had no notice of this witness?
Yes, Justice Brobson. So I think when we look, and the section is pulled right from Appellee's brief. The mention was, I object strenuously, Your Honor, and this is on page 5, from the fact that I have not received an expert report, I have not received a CV, etc. So due to those reasons, I would object to that.
Right.
I think given that context, it's quite apparent that he was not put on notice that they were going to call or try to qualify this guidance counselor.
Well, how are you telling me that if there would have been notice, a witness list, but no CV, that the CV objection couldn't have been raised?
He could have raised that objection as well, but I think given
Then why should I read the transcript that this isn't just a CV objection, that this is an objection beyond just a CV objection, and it's a pure, we didn't even have we're being ambushed, in other words. How do I read that objection on the record and conclude it was an ambush objection as opposed to just we haven't received a CV?
I think given the context, it's readily apparent from the situation. The Commonwealth is moving now to qualify this guidance counselor, who at no prior time had they given any indication they were going to call as a witness.
But I don't know that. I don't know that. All I know is I'm reading the transcript, and clearly counsel could have said, Your Honor, this is ambush. This witness we were never told anything about this witness, let alone get a CV. But this is a complete surprise. You can't allow this to happen. But as I read the transcript on a cold record, that doesn't seem to be what happened here. What seemed to be happening here, Your Honor, we object. We don't have a CV for this witness.
And see, I respectfully disagree with that. I think that he was so caught at that moment. All of a sudden, they're trying to qualify, and they didn't even state.
But they're two
Section
different
59
objections.
Sorry.
Pardon me, they're two different objections. That's what I'm concerned about. They are two different arguments. We weren't given notice that this witness would testify, or we knew about the witness but didn't have a CV, didn't know that she was going to offer expert testimony. I mean, it is a little bit murky as to what happened here.
Yes, there was no indication either in the post-sentence, at the hearing on the post-sentence motions, that trial counsel actually ever had any indication that they were going to call this guidance counselor as a witness. The objection was for no CV, no report, all the hallmarks of things typically you're going to receive from the Commonwealth to let you know we're going to be calling this person as a witness.
As an expert witness.
And also mentioned, et cetera. I mean,
Counselor, is it your argument that the application of 5920 requires compliance with Criminal Rule Procedure 573?
correct, Your Honor. And I'm basing that off of the 6 justices that participated and done in both of their opinions, all agreed to that.
That's the gist of your argument, correct?
Correct. So 573 would apply, that given the circumstances here, mid-trial, no advance notice that they were going to call this guidance counselor as an expert under 5920. They had no ability to even request a report. This was scheduled for a one-day trial. The testimony in this trial was completed after 2 hours. The idea that the trial judge would have been able to somehow continue it is out of the question. Because jeopardy had attached at this point. They were 2 witnesses deep. They had the affiant testify and the child had already testified. At that point, then, they call this guidance counselor. And then they seek to qualify them as a witness. This is a lot different than in Dunn, where it was the night before.
Well, I understand that, but you can ask for a continuance in the middle of trial. Say, Your Honor, I'm not prepared. I didn't know anything about this witness. And the judge could have said, I'll give you till tomorrow to get prepared. We'll reconvene tomorrow with this witness.
So the problem with that is the jury itself was...
Was there ever an ask?
There was never an ask for a
Now
continuance.
tell me your problem with it.
But I would still argue that it's substantially different from the situation in Dunn, which would have occurred beforehand. This jury was selected for one day. Their availability of all the jurors, it's just not practical to be able to say all of you are going to need to come back. And even on that regard, that gives you, maybe we say we continue it overnight and we allow the Commonwealth to confer with this expert and be able to provide some kind of report, such as was provided.
Well, you could have gone to sidebar and asked for an offer of proof on what she was going to testify to.
Yeah.
And then take your day or the rest of your day to prepare and reconvene and complete the trial.
Except the burden falls on the Commonwealth to provide that material, not at the expense of the defendant.
Correct. And how is he going to have any opportunity to go reach out to his own, understanding that 5920 allows him to do that on his own, but now he's just being confronted mid-trial.
That's your argument. If you get in a report beforehand, you can actually get your own expert, give him or her the report, and say, is this correct? Would you like to perform your own report? If not, and they say everything is correct, then that expert that you're consulting with can also provide you with critical cross-examination.
Critical cross-examination, vetting all of the different materials that expert would have relied upon.
That's the prejudice.
And that's the prejudice. It's in many ways similar to the prejudice that was brought out and done, but however done.
Counsel, did you ever argue that prejudice? I'm reading the transcript. I mean, what you just said now would have been a wonderful argument as to prejudice, but the best I could tell, that argument was never made.
So I do believe it was preserved, and so I do believe it was argued in the Superior Court brief. Trial counsel indicated that because of the decision of the judge to allow the testimony, was unable to be permitted to be prepared for trial. That's
and we
prejudice.
should infer, and the court should infer prejudice. I didn't see any argument.
And how about the trial court? I mean, when was that argument made to the trial court? Had we had known, we could have gotten our own expert, or I could have prepared otherwise by doing research, et cetera. I mean, I don't know when that argument was made before the trial court.
During the trial, not. In the post-sentence motions and the hearing on that matter, it was. And that's where the trial judge himself even acknowledged.
Well, but the argument that was made before the trial court was, I was ambushed.
Correct.
And then the trial judge is supposed to infer what that means? I was ambushed and then, therefore, I could not. I mean, I'm just wondering where this prejudice argument was made in the trial court, which, as you know, was a critical aspect of the Dunn decision.
Yes, that was the split and Dunn.
Well, and that's what I'm saying. All the more reason for us to look at this record and see where is the argument made as to the prejudice that was incurred.
The argument was not fleshed out nearly to the same degree, and part of the reason for that was there was no report like there was in Dunn. There was no way to go back and to research and to consult with a different justice or to consult with a different expert, because you didn't even have that testimony and you didn't have the report that you had initially. What I think is a problem here is that it's apparent there was a discovery violation. The Commonwealth sprung this expert mid-trial without any advance notice, without the CV, without the report, etc. The trial court, the judge, erred by allowing that testimony. Should have precluded it. Should have should have done any number of things rather than just allow that expert to then testify over the trial court's objection.
But that gets back to the point. I mean, if the objection was no notice, that opens up a variety of responses from the trial court. However, if the objection is, I didn't get an expert report, that limits a response that the trial judge is going to be able to make. And, you know, back to this question, I mean, you know, I don't see anything in the record that would suggest that the trial judge knew that there was no notice that this witness was going to be called.
Yes, I think that was apparent from the objection that was made.
I don't have an expert report. That's a different objection.
I don't have the CV. I never received the CV. I never received.
But that could have, again, I'm reading it as a cold record, right?
Right.
If I'm reading that transcript, that argument could simply be, we requested it under the rules of criminal procedure and they have not provided it.
There was a request. There was an initial discovery request when trial counsel took over the case that largely tracked the language of 573.
Right.
The Commonwealth never provided anything, never provided any notice.
Right, and that's the argument you made. We asked for the CV and they didn't give it to us.
We asked for the report, we asked for any materials, and they have a continuing duty to disclose under 573D.
Right.
And if the moment, and they obviously, this guidance counselor lived and worked in New York State. She was subpoenaed for trial. The Commonwealth utilized the testimony it got from her in its closing argument. About 20% of the closing argument.
My questioning and my concern in this case is not about whether the district attorney acted properly or not. And I'm not saying they did or they didn't at this point in time. My focus of my questioning has been on, did trial counsel raise the right objection? And is this objection about lack of notice before us? Because it seems to me it's a separate, and you haven't really convinced me yet, I'm still open to be convincing, that lack of notice versus lack of CV are the same thing.
I understand that, Justice Robson. However, I just continue to point to the context, and I believe it was readily apparent. Under Rule 103, I think it's preserved. I think that the way this went down, the way this exchange transpired, because all of a sudden, they're calling the child's guidance counselor, again, never mentioned once in the police report, in discovery. You're calling this witness, and now you're going to try and qualify her as an expert in child sex abuse behavior. On the spot, mid-trial, defense counsel stands up and says, Your Honor, I object strenuously. I've never received a report, I've never received the CV, etc. I think that given that context, it's quite apparent that he was surprised by it and he was objecting to never having any notice in advance of receipt of the Commonwealth's intent to call this expert. And I don't believe, and to shift it, I understand the large prejudice debate that went on in the various opinions in Dunn. However, harmless error analysis here places the burden on the Commonwealth to show, right, beyond a reasonable doubt that this error was harmless. I don't believe they can do that. This testimony This was not the typical sanitized 5920 expert that's become commonplace. This was the child's guidance counsel. If you review the transcript of the testimony, pages 71 through 73, you will see that not only does the guidance counselor get into some of that more generalized type victim behavior we associate with 5920, but also brings up areas, I would argue, touching on credibility, such as this child is so intelligent, she's so very engaged, that it wasn't until she was able to move up into a different state that she got comfortable.
How old was the child at the time of trial?
Time of trial, 14 years old.
Okay, and how old was the child at the time that she reported the offenses?
I believe it ended at the age of 9.
9. So, at some point in time, you had to realize that one of your key defenses to this case would be lack of memory or inaccurate memory.
Or delayed reporting, certainly, yes. Yeah, obviously. And as I stated, the way that the prosecutor on pages, I mean, it roughly worked out to about 20% of the prosecutor's closing pages, 116, 117, and 120 in the transcripts, worked that directly into her theory of the case. This is not something you came up with on the spot. You knew you were going to use this guidance counselor as an expert under 5920. You never gave any notice to defense counsel. Nobody even ever used the term, nobody even cited the statute between trial counsel, the Commonwealth, nor trial judge at the time of the trial. She just moved to qualify that expert. The court allowed it and allowed her to testify, and that testimony was significant. This was not a slam dunk prosecution. There was 178 counts here. Mr. Adams was acquitted of 116 of those counts. You can't discount the impact that testimony from the child's guidance counselor, who is able to testify in that hybrid manner about typical victims of sex behavior, of sex crimes behaviors, as well as her own personal knowledge and understanding from over a 2-year period meeting with the child on a near weekly basis. That's significant. That's something that if it had been litigated ahead of time, very well and very likely would have parsed out that testimony, because that's why prosecutors have moved toward this more approach where you have that sanitized type expert that doesn't have that same type of direct involvement with the complainant, and then when the prosecution calls them, tends to do it through the use of hypotheticals. Here it was a hybrid.
Was there a 10 years motion filed in this case?
So there was for the preliminary hearing. There was no I'm sorry. That was an objection throughout the rest of the trial in the different transcripts. Never a tender years motion held. There was that alternative means of testimony for the preliminary hearing, which was ultimately stipulated to by original counsel. So it never had to get to the point where this guidance counselor would have been called as part of that pre-preliminary hearing alternative means. So she never testified previously, this guidance counselor.
Could you clarify something for me? The trial judge, President Judge Nancy Butts, heard the case. Was she the judge who entered the new trial order, or was that the senior judge that stepped in?
That was senior. The senior judge was the trial judge, Judge Kenneth Brown.
Okay.
And he's the one that heard the post-sentence motions. He applied his own harmless error doctrine and found that it wasn't harmless error, found that he warranted a new trial. However, it was past 150 days, and therefore was unable to take effect.
I misunderstood that. All right, thank you.
Yes.
Anything else?
Yes, so it really boils down to that. It was a clear-cut violation, clear-cut discovery violation. The trial court erred in allowing the testimony. That was not harmless error. Harmless error is the burden of the Commonwealth. To date, I've not heard any argument necessarily showing why, beyond a reasonable doubt, allowing this testimony from this guidance counselor, qualified as an expert under 5920, was harmless error. I don't believe that they can meet that burden. And I would argue about the idea that we need to show a specific quantum of prejudice. to overcome that. I think the harmless error analysis in this case warrants the finding of a new trial under Counterman. He was denied a fair trial. Counterman was cited by both Justices Donahue, Mundy, in both of the opinions.
There were 3 opinions.
And I didn't want to leave you out, Justice.
You just didn't bother reading that.
Just
Sorry.
don't forget Justice Weck's opinion.
And it was,
You did forget it. You did forget it.
well, I didn't forget it.
I didn't forget it.
I tried to form much of my argument around that flipping of the burden, really, in the harmless error analysis. That it doesn't need, the defendant doesn't need, it's not the defendant's burden to come up here and meet this certain quantum. He stated, albeit briefly, in the Superior Court brief that he was unable to be prepared for trial. That establishes prejudice. The prejudice is apparent from how the situation went down. Mid-trial, no ability to even exercise 573B2B, could not request a report, could have, but it wouldn't have been practical, as we stated, and wouldn't have been able to do any of the research needed to combat it and prepare for trial.
The problem from my perspective, and you are aware what I wrote in the Dunn case, is that discovery violation doesn't equal new trial. Discovery violation, prejudice, then you get new trial. And truly, my issue with it is that I don't think prejudice was argued until you got to the appellate courts. It did not appear in the trial court, in my opinion, but my colleagues may differ.
Yeah, and I think given the nature of this situation, the prejudice was apparent.
Can I just follow up on that?
Yes.
The one guy that wasn't undone.
I'm deaf in one ear, so I can't.
Didn't the trial judge write an opinion in response to the post-trial motions finding that there was actual prejudice?
Correct.
So we don't even have to concern ourselves with the prejudice. The trial judge found it.
He found it and he ordered a new trial. However, it was by operation of law past 150 days.
Yeah, I'm pretty sure of that. All right, thank you.
Well, prejudice is a legal conclusion, right? All right, thank you. Let's hear from your opposing counsel. Ms. Feast?
Morning. A little bit shorter. All right. Morning, Jessica Feast for Lycoming County District Attorney's Office for the Commonwealth of Pennsylvania.
Did you try the case?
I did not try the case either.
Okay.
So I do think that the question that we're here to address is different than Attorney Walkovich presented it. The question that Alicata was granted on was whether the trial court erred in permitting the testimony of the Commonwealth's expert. The objection as raised by defense at the trial was on, he objected to the fact that he had not received a CV and he hadn't received an expert report. So Commonwealth's position is that the trial court can only rule on the objection that's presented to it at the time. And the objection presented was no report and no CV.
Well, anybody who's tried a case or presided in a case ought to understand when the defense gets ambushed like this and defense counsel says, quote, "I object strenuously, Your Honor, from the fact that I have not received an expert report, I have not received a CV, etc. So due to those reasons, I would object to that." You seem to say that the word notice is a magic word, that since defense counsel didn't use the magic word of notice, that the trial judge couldn't possibly understand that the defense lawyer was saying he's ambushed here. Isn't that your point?
No, Your Honor, I'm not saying that notice is a magic word or that the trial court couldn't understand that. I shouldn't say that. An expert report is not mandatory. Obviously, mandatory discovery would include an expert opinion, and then the report can be ordered later or requested later. So I think that the way that trial counsel presented it, the court ruled on the objection in front of it, just lack of CV, lack of report. I don't think it necessarily follows that he didn't have notice at all.
So
I think that...
Let's stop right there. Is it your argument that if you're utilizing 5920 for an expert, you don't have to comply with 573?
No, that's not my argument, and I don't think, so not providing an expert report is does not mean you're not in compliance with Rule 573. Obviously, the expert opinion, some kind of notice is required under 573, not necessarily a formal report, and I think that's where some of that confusion can lie, is that defense objected to that lack of report and lack of CV, not lack of notice. I think that because we have the expert opinion is under mandatory discovery, and whether or not a report is produced is under discretionary, I think that's probably where some of the confusion came from here.
You're failing to take into consideration that the witness, the expert witness, was actually the child's counselor, so there, commonsensically, there would be a plethora of information that she had written with her contact with that person. Is it your position that's not relevant under 573? That you should have provided that information if you're calling the counselor as an expert?
So by calling the counselor as an expert for her expert opinion on children, like typical victim behaviors, I don't think that her counseling records with the child would fall under...
But her testimony, if I'm not mistaken, dealt directly with issues regarding that particular child, not a generalized.
Yes, her testimony did delve in there. That was probably in violation of 5920. That should have been an objection. No objection was made.
Wait a minute, are you saying, now I'm confused. As I read your brief, I did not see you disputing Adams' assertions of prejudice. It seemed like you're relying exclusively on waiver. But now as you're arguing here today, in response to Justice Dougherty, are you saying that the Commonwealth did not violate the rules and that there's no prejudice? Are you making that argument as well?
No, sir. I'm sorry. I don't follow how that...
I take it that your argument here is entirely waiver. As I flip through your brief, it's a brief, you seem to stand only on a waiver argument, but in listening to your answers here, it seems like you're backpedaling. You're trying to suggest there wasn't a violation and that there's no prejudice. What exactly is the Commonwealth's argument here?
Argument first, Your Honor, is that the court ruled on the objection in front of it, which was not no notice. It was no CV and no report. From that, yes, I am arguing that there was waiver because the defense did not argue prejudice in its appeal to the Superior Court.
So what would be what in your view would be the appropriate remedy for the clear discovery violation? I mean, you can't dispute there's a violation of 573D. I mean, what would be the appropriate remedy here for this violation that's even more egregious than what happened in Dunn? This is in the middle of trial, jury's in the box.
Okay. So middle of the trial, jury's in the box. Defense says we don't have an expert report and we don't have a CV. Continuance is a possibility. A recess, as I think they had a recess in Counterman. I know that wasn't an
Let's stop right there. The burden is on the Commonwealth pursuant to the rule. Why is it incumbent upon the defendant to stop and request a jury in the midst of a jury trial, look like they're ineffective or unprepared based upon being sabotaged by the Commonwealth?
Okay.
That's my concern. Tell me why your argument right there carries any weight with this court.
Okay.
Because what you're saying is we don't have to give you anything.
No, that's
But we're in
not what
front
I'm
of a
saying.
jury trial, and now we're going to tell you, and the request is you, defendant, have to request a continuance and keep your client in jail or whatever, so that the appearance in front of the jury is defense attorney's not prepared.
Okay.
That's not fair, because that's what the rules do not permit. But you're asking us to accept that. Explain to me that.
I am not defending how the trial was handled by that attorney from the Commonwealth's position. What we are dealing with here is whether or not the trial court erred in making a ruling on the objection that was made in front of it.
But didn't the trial court issue an opinion in response to the post-trial motion saying, I made a mistake, it's clearly prejudicial? I mean, everything Justice Weck, Justice Dougherty, and everybody else is asking you about prejudice and about whether or not there is prejudice and who's got the burden of proof, the trial court acknowledged, based upon the totality of circumstances, based upon what happened, and the judge sitting up there at the trial court, he's got the best view of what happened. The judge said there's clearly prejudice here.
The trial court did find that there was prejudice. Now, I think if you the way you read the post-sentence opinion, I also don't think that the trial court saw that initial objection as saying that they had no notice at all.
Yeah, but I understand that, but maybe my experience is a little bit different, but having tried as many criminal cases as I've tried and as civil cases, in the context of a civil case, if an attorney, a plaintiff's counsel, walked up in the middle of a criminal trial and said, Judge, I'm calling an expert, and the defense attorney had no notice of it and it was sitting there, that would be an automatic mistrial. At the drop of a hat. I can't see under any circumstances why you're asking us to countenance the same type of discovery violation in the context of a criminal prosecution where somebody's liberty is at stake, which is so much more important than civil remedies. I mean, you have a clear violation of a rule. You have a defense attorney who's sitting there, no notice, no expert report, nothing, no ability to kind of get their own expert, no ability to consult with their own expert about the report. And I know we're going to argue in the back about whether or not this constitutes quote-unquote prejudice, but I can't see anything more prejudicial to a defense attorney than sitting there and getting hit with an expert at the time of trial without an expert report or no notice. And now we're going to argue about whether or not they properly preserved it and made a prejudicial argument at the time of trial? That's a lot of words, I'm sorry about that.
No, that's okay, I'm trying to find
I'm
exactly.
just wondering, what is it you contend? Because as Justice Doherty just mentioned, we've got a clear violation. What do you think the remedy is, and whose burden is it to show prejudice? And if you're going to say it's a defense burden, what do they have to show or to object at the time of trial to have it excluded?
I don't know, and perhaps I'm misunderstanding. I didn't believe that defense was required at the trial level to show prejudice. I think that it wasn't properly preserved through their superior court argument.
Why do you say they have to? I mean, they raised it in a post-trial motion, and the judge dealt with it in a post-trial motion. What more do you need?
For it to be raised in front of the superior court for preservation of the argument that there was prejudice. They didn't argue prejudice.
So notwithstanding that your brief only makes this waiver argument, you're not renouncing a claim that he wasn't prejudiced. You're maintaining that this guy was not prejudiced by this ambush tactic.
No, I'm saying that he waived the...
So you are relying strictly on this waiver argument?
Yes.
Uh-huh.
Do you have any further argument, Ms. Feast?
Okay, just a moment. No, Your Honors, I think that covered everything. Thank you.
All right, thank you both very much.
you.
Very good.
Schmidt as the administratrix of the estate of Jeffrey J. Smith versus PennDOT for Marion Township, representing Appellant Mr. Howard Bashman, representing PennDOT Mr. Damon Mullen, representing for Marion Township Mr. Michael Sam.
Good morning. The Commonwealth enjoys sovereign immunity against tort liability except where it is waived by the General Assembly. In this appeal, Jeffrey Schmidt sustained fatal injuries after a rotted portion of a tree overhanging a Commonwealth highway fell and crushed his vehicle. Relevant for purposes of this appeal, although the portion of the tree that fell extended over the road and PennDOT's right-of-way, the base of the tree was located outside of that right-of-way. We granted aliquotter to consider whether the overhanging portion of the tree constituted a dangerous condition of Commonwealth real estate, thereby satisfying the real property exception to the Commonwealth's sovereign immunity. As I understand it, there will be one argument by the appellant and two separate arguments by the Aplts. All right, please proceed.
Good morning, Chief Justice Todd, and may it please the court. My name is Howard Bashman, and I represent the plaintiff appellant Ellen Schmidt as administratrix of the estate of Jeffrey Schmidt, With me at council table is David Quas of the Salts-Magaluzzi Law Firm, co-counsel in the case.
And I'll tell you all, this is a very interesting case. Very interesting case, so go ahead.
Thank you. As you explained, Chief Justice Todd, this case implicates subsection B4 of the exceptions to sovereign immunity statute that applies to Commonwealth real estate. And what that statute states at its outset is that sovereign immunity is waived where there exists a dangerous condition of Commonwealth agency real estate and sidewalks, including Commonwealth-owned real property. In this case, plaintiff's expert witness, arborist, and tree risk assessor opined in his expert report, which was before the trial court at the summary judgment stage, that the part of the tree that was rotted, decayed, and diseased, and that fell and killed plaintiff's husband was located directly above PennDOT's roadway. The dangerous condition was located within PennDOT's right-of-way. Under this court's decision in Snyder versus Harmon from 1989, the dangerous condition must derive from, originate from, or have as its source Commonwealth realty. It is our position in this case that where the rotted portion of the tree that failed exists directly above the Commonwealth roadway, that is a dangerous condition that originates from the Commonwealth's real estate, because the Commonwealth's real estate does not consist merely of the dirt. And as I said at the outset, this provision waives for real estate and real property being even more broad than just real estate, but rather it also extends upward to the sky and down to the center of the earth.
If you're including airspace generally, would you include bridges, trestles, power lines, anything going over the Commonwealth's highway?
Well, if it became a dangerous condition, I mean, the hypothetical that comes to mind for me, and this may be somewhat absurd, would be, these cantilever arms that we see now on the interstates, which are just incredibly huge. What if a private property owner erected one of those and put an art installation on top of the interstate or the Pennsylvania Turnpike, and the purpose of the art installation was, this is a dangerous thing that someday is going to fall down here. Well, if that's permanently there on top of the Commonwealth real estate, the Commonwealth's position is, that's not a dangerous condition of our real estate because it's connected to the ground on the adjoining owner's property. And so, we do draw a distinction between the circumstances that are not persistent the way that this tree was. This is an American sycamore that lives for hundreds of years.
What about a rusty bridge that gets worse every year?
If the bridge is deteriorating over the Commonwealth roadway and it's not Commonwealth property, which I assume is a assumption of Your Honor's question, because obviously if it is, then it's covered in any event. We think that could be a circumstance that would give rise to liability because it's
under your theory, Mr. Bashman, the Commonwealth owns the bridge.
I'm sorry, I missed the very beginning.
Under your theory, the Commonwealth owns the bridge, just by virtue of the fact that, under your theory of this case, the Commonwealth owns anything from hell to heaven above its ground property. Owns it.
It is a dangerous condition of Commonwealth real property.
No. You're saying they own it. You're relying heaven to hell, is your theory, which means they owned the tree that was over top, not the tree, the branch. They didn't own the tree. They just owned this branch. And if your theory is adopted, they also own the bridge. They also own, regardless of whether it's a dangerous condition or not, it's property of the Commonwealth.
The Commonwealth is allowing this dangerous trespass to exist, which gives rise to a dangerous condition.
So you're changing the facts.
They're responsible for it.
Yeah.
Right. I'm saying that they're responsible for it. We do not dispute the fact that in Pennsylvania, the owner of the tree is based upon where the trunk goes into the ground. So I'm not saying that the Commonwealth, and by the way, the Commonwealth does own the tree because it's SEPTA property and that's a separate Commonwealth entity, but that's beside the point.
Well, it's not beside the point because you'll recover from one or the other. Well, and you'll hit, maybe, unless you want to try to double the cap.
That's not necessarily
It's not germane to the legal issue.
true, because the tree was not dangerous above SEPTA property. Approximately 10 days before my client was killed in this winter storm, some good Samaritan called PennDOT and said, there's a dangerous tree limb at this very location. And
it's not the ownership of the thing, it's the ownership of the duty. So the duty and tort can, you're saying, speak to the immunity question in this context. Isn't that right?
Yes, and so all that the statute requires is a dangerous condition of Commonwealth real property, not that the Commonwealth owns the thing that's giving rise to the dangerous condition.
How do you respond then to the Commonwealth's argument about the implications of the notice aspect there? In other words, how would you recommend this court set parameters for the universe of cases out there where rotting tree branches could be leaning over roads or deteriorating bridges, for that matter? What would be the common law rule to set there?
Well, certainly there's no such thing as strict liability in tree damage cases. So one aspect of what plaintiffs will need to prove at this trial, which we're very much hoping to pursue, is that the Commonwealth was negligent. And for purposes of this appeal, the Commonwealth does not dispute at the summary judgment stage that the plaintiff has sufficient evidence to reach a jury on that point. So the argument that somehow the Commonwealth now becomes liable for any instance when a tree falls onto a roadway is false for two reasons. The first reason is the patent case from the Commonwealth Court from 1996 involved a tree that was damaged above the roadway, and liability was found to exist there. The Clark case, which is a separate case where the tree split in half from adjoining land off the road, in that case, the Commonwealth Court correctly held that the PennDOT was not liable because the damaged portion of the tree was not over the road. And so in that case, the diseased part of the tree was the trunk. In our case, the diseased part of the tree is the limb above the road.
But doesn't the distinction have to turn on whether the dangerous condition was one that the Commonwealth knew or should have known, rather than an act of God? Because an act
Absolutely.
of God could create the right.
No, I agree that we also have to prove that the Commonwealth's negligence was negligent under the circumstances. And again, that is assumed for purposes of this case.
Mr. Bashman, do I understand your argument of Commonwealth Agency real estate includes airspace?
Yes. And indeed, if one looks to this court's decision in the Wise case from 2021 that Chief Justice Baer wrote, and I believe that 5 members of the current court sat on, which involved a situation of inadequate lighting. In that case, this court found that the real estate exception was triggered by plaintiff's allegation of inadequate lighting. And lighting is even more attenuated in terms of not being attached to anything. It's
attached to a pole.
Yeah.
Well, there's a light that's attached to the pole, but the light from the pole is being blocked by a tree and some other things. And maybe you even have a case where the tree limb is coming from off of Commonwealth property and blocking the light. And I think in the Wise case, the outcome would still be the same, whether it was a tree on the Commonwealth property or a tree from off.
Counsel, that's a little bit attenuated. I mean, back to Justice Doherty's point. I mean, your argument involves the space above. Here we have a highway. I mean, it didn't have to be a tree. It could have been Chief Justice Todd's example. It could have been a bridge that had concrete falling from it onto the roadway. The question is, does the Commonwealth have the obligation, do they have the duty to maintain their roadway in a manner that would include taking care of that dangerous overhanging condition?
Right. And I know that there's been some discussion in separate opinions, one of which I believe you joined, Justice Donahue, saying that, in an appropriate case, that should be the Commonwealth's duty. If the Commonwealth allows a dangerous condition to exist on its roadway, whether it's through action or inaction.
I didn't join that opinion, I wrote that opinion.
Right, right.
And, and I, you know, I'm questioning, I mean, I get the notion that the leader of this tree was the culprit in this case.
Yes.
But the real issue is, does the Commonwealth have a duty in the context of maintaining their real property in such a fashion to prevent this known problem from creating the exact danger that it created?
And, you know, I think, I realize that that may be a very difficult question at some levels, but in actuality, you know, the phone call came in, the next day the Commonwealth went out and took a look at the situation. And the reason it didn't do anything, I believe the record supports, is that the person who went and took a look was characterized by a more senior Commonwealth employee later in depositions as having been unqualified and did a bad job in looking.
That'd be a fact issue on dangerous condition.
Yeah.
So that'd be trial. That'd get you in front of a fact finder.
So, yes, and so if this Commonwealth employee went out and took a look and saw that the tree was in a dangerous condition above the Commonwealth roadway, she wasn't going to then decide that it was on SEPTA property and so we'll ignore it. But that is the risk that I believe this court could create if the court affirms the Commonwealth Court, which is that now the Commonwealth will not be motivated to take action to address dangers that exist above its property that it's aware of, because it faces no liability as a result of not doing that.
Well, but that's arguments against immunity for everything. You know, like, how do you deal with the language in Snyder that says that the dangerous condition has to derive, originate, or have its source in the realty?
Yes.
I mean, the only way you can address that is by arguing that the Commonwealth owned the airspace above the road.
The Commonwealth does own the airspace above the road, but
From
yes.
heaven to hell. From
Yes.
heaven to hell, including power lines, including bridges, including anything that is over the real estate, that it's basically tax-exempt property.
Obviously, power lines are not ordinarily going to be dangerous conditions.
Well, that's not true, because I live in a valley where power lines fall down all the time.
Okay, well, that may be due to something that is not obvious beforehand, perhaps, but let me address...
Well, it could be a rotted freight power line that was damaged through many, many storms and is just kind of hanging there low and is at risk of breaking at any point in time.
If the Commonwealth had notice of that, then I think that the same result would apply. But let me answer your main question, which was about Snyder, because that is a key point in this case. Snyder said that the dangerous condition must, and I'm just going to say the exact same thing you just said, must derive from, originate from, or have as its source Commonwealth Realty. And again, I don't think that was an example of belts and suspenders. I think those are three separate things. And in our case, at a minimum, we think that we satisfy the originate from prong of Snyder because the dangerous, diseased, and rotted portion of the tree was above the Commonwealth Realty.
But it didn't exist by itself. The tree was attached. It's a tree.
Right.
It's not a hanging limb in the middle of the air. It's a tree that comes down on someone else's property.
If I have a neighbor's tree over my property they know has a rotted limb, and I decide to have guests over and throw the party under that rotted limb, you know, I think that there's a pretty good argument that I could be liable if those guests sustain injuries, even though the owner of that tree is my next door neighbor, because I was aware of the condition.
Mr. Bashman,
yes.
I'm still a little confused because I thought we had established that you were arguing responsible for the Commonwealth was responsible for things in the airspace above its highway, but then I thought you agreed with Justice Brobson that you're actually arguing that they own the space above the...
To my point, Snyder doesn't talk about who's responsible for it. It doesn't talk about who has a duty to ameliorate a risk. It simply talks about the defective condition must derive from, originate, or have its source in Commonwealth real estate,
right.
not real estate that the Commonwealth has a privilege to do something with.
So could you just clarify that for me? Are you arguing that in this kind of situation the Commonwealth owns everything in the airspace?
What we're saying is that the term real property, which is also in this section B4, is the entire bundle of rights that includes not just the surface, but everything above and below the ground. Now, someone might come in from the federal government and say, you know, at some point, there's rights that belong to air travel, you know, that can be used by airplanes and things like that. So it doesn't extend indefinitely.
Well, it's the distinction there. That's the famous chicken case, right? So the FAA can fly the airplanes back and forth, but you're not talking about transient conditions.
Correct.
You're talking about dangerous conditions of the real estate. You're saying that from heaven to hell, these things known to on which the Commonwealth's on notice, the Commonwealth's responsible for.
Correct. And this lightning strike hit the tree over the road, and that is where the danger originated, was in that spot. And that spot is Commonwealth real estate because it's above the road. And so this is a condition that originates from Commonwealth, a dangerous condition that originates from Commonwealth real estate. That's my argument.
Okay.
So we ask that you would reverse, unless there's any other questions.
Thank you very much.
Thank you.
Let's hear from Mr. Mullen.
Madam Chief Justice, and may it please the court, my name is Daniel Mullen. I'm with the Pennsylvania Attorney General's Office, and I'm here representing Aplt PennDOT. With me here today is my co-counsel, Deputy Attorney General Hannah Kogan, who did excellent work on the brief in this case. Also here today is counsel for Upper Marion Township, Michael Salick. I'm going to just quickly go over the division of labor between myself and Mr. Salick before I dive into my argument. I'm going to address the main issue before the court today, the issue on which Arcadia was granted, which is whether or not PennDOT enjoys sovereign immunity from suit in this case. Mr. Salick will then address how the court's disposition of that question could impact liability for municipalities.
Can I just ask,
Please.
how does Upper Marion get to argue they settled the case?
It's a good...
We don't let amici argue except by leave.
It's a good question, Justice Wecht.
They're an appellee of
They're by default an appellee, and they filed a brief, and I...
Matter's been satisfied as to them, right?
That's right. They settled the case.
I still don't understand how they get to argue.
I'm, not entirely sure either, Justice Wecht. I mean, I think the rules say that by default, if you're not an appellant, you're an appellee. I suppose we could have...
They're still an appellee of record, I believe.
Correct, and they elected to participate. I didn't, see that there was
And I
space for
said
us
yes,
to...
so-
And the Chief Justice said yes,
I guess
most
if
importantly.
I voted, I would have said no.
Yeah, and
The case is over for them.
most importantly, for my purpose, they supported our argument, so we didn't see any reason to, move to strike their brief or anything like that.
Okay. Let's
So, yeah, we think the court should affirm the Commonwealth Court's ruling that this case falls outside the plain text of the Sovereign Immunity Act. As this court is well aware, the General Assembly enacted the Sovereign Immunity Act to insulate the Commonwealth not just from tort liability, but from suit altogether, except in certain enumerated circumstances. And it is well established that the exceptions to sovereign immunity must be strictly construed consistent with the General Assembly's intent. As has been discussed already, the text of the real estate exception limits the Commonwealth's liability to dangerous conditions that are, quote, of Commonwealth agency real estate. My friend's interpretation of that exception is untenable for 3 reasons. First, it's contrary to the plain text. Second, it's contrary to 40 years of this court's decisions interpreting that plain text. Dating back to Snyder in 1989 and continuing through Jones, Kagi, and Wise, this court has consistently interpreted the phrase of Commonwealth agency real estate to require that the condition derive, originate from, or have as its source the Commonwealth's land. It must be the land itself. Third, my friend's interpretation would upend 30 years of Commonwealth Court jurisprudence, which has faithfully and consistently applied both the text of the real estate exception and this court's precedents dating back to Snyder to injurious tree cases where the base of the tree is situated on non-Commonwealth property. Again, those decisions correctly look at the base to determine who owns the tree and whether or not it is of the Commonwealth agency's land. Here, because the tree was situated in SEPTA's land, not PennDOT's, the Commonwealth Court correctly determined that PennDOT enjoys sovereign immunity. This court should reject my friend's request to have hundreds of thousands, if not millions of trees that trespass upon the Commonwealth's airspace be deemed of the Commonwealth's land. As the Commonwealth Court correctly highlighted, that novel argument would dramatically expand the real estate exception beyond what the General Assembly intended with its text. And this court has said many times that the plain text of the real estate exception is unambiguous, but I want to point the court towards another provision which I think reinforces that conclusion, and that's the Political Subdivision Tort Claims Act, which was enacted on the exact same day. And if you review the two statutes side by side, the Political Subdivision Tort Claims Act waives liability for municipalities for property that is within their care, custody, or control. And they have a specific tree exception as well, which again uses that same language, care, custody, or control. And we have to distinguish that from the language in the real estate exception to sovereign immunity of Commonwealth agency real estate. And I think we have to effectuate the difference between the language in those two statutes. And if you were to hold that something that trespasses or encroaches upon our airspace is of the Commonwealth's land, I think we're essentially grafting onto the Sovereign Immunity Act that care, custody, and control language that, again, does not appear in the Sovereign Immunity Act, but does appear in a different statute. I welcome any questions the court may have for me. Please, Justice Wecht.
So, since you're a Pittsburgher,
Yep.
so you're coming in from the airport, and you drive under that massive Norfolk Southern Railway Bridge in Carnegie, and it's crumbling. Actually, this happened in the Greenfield Bridge years ago, right? That was shut down.
Yeah.
So there's big chunks of concrete. Now assume a scenario where the Commonwealth knows about it, as it learned with the Greenfield Bridge, right? You might shut the whole highway down in order to repair it, just like you did with the Greenfield Bridge. Now, isn't that a dangerous condition of your roadway? Regardless of the fact that you might not own the bridge or whatever it is that's overhanging it. In other words, putting the ownership question aside, is there not a dangerous condition of that road because of what's hanging over it and dropping chunks of concrete?
I'm not sure I fully understand all the details of that, but Justice, I don't know that we can set the ownership issue aside. That's the sole issue in this case, is who owns the tree.
Well, you want to go with ownership as a term of art, but ownership, not the language in the statute is a dangerous condition of Commonwealth agency real estate, right? So is there a dangerous condition of your road if there's this thing hanging above that's going to drop?
I would say no, that's a dangerous condition of the bridge, and something that overhangs our airspace or trespasses on our airspace is not of the land. To determine whether or not something is of our real estate, you have to look to the ground, not the airspace.
So what does PennDOT do when it receives a phone call from a resident saying there's a rotting bridge above that road?
Yeah, I think the same thing we do in any case. We investigate it, we bring in the appropriate parties, and the owner of the bridge, I think in that scenario, we would alert them that, hey, there's this condition that you need to fix so that it doesn't drop down on the height.
No, you actually have the right to take that tree down by law.
PennDOT does we do have a statutory...
About the bridge.
Well,
Do you have the right to take the bridge down?
No, we of course don't have the right to take the bridge down. We don't have the right to take utilities down, to another example you referenced earlier, Justice.
You have a right to close the roadway?
We might have a right to close the roadway, and Justice Wecht, to your point...
It's a problem of the real estate.
Sorry, say it again, Justice Donahue.
Because there exists a problem of the real estate, of the property, because of the problem that hovers above it.
No, I don't think that renders it a condition of the real estate, Justice Donahue. And I think
it's a dangerous condition of the real estate. Under that scenario, it is a dangerous condition of the real estate. It makes it treacherous for motorists to pass.
I respectfully disagree, Justice Donahue. I think to be a dangerous condition of the real estate, we have to look at what's affixed to the land.
What if I say, Mr. Mullen, I've got a pool. Why don't you bring your wife and child over, and we'll have a pool party? So you come over, and there's this overhanging massive tree branch about to fall on you, or a wire that's about to fall on you. Is it not a dangerous condition of my real estate?
Yes.
Not necessarily, no. If you don't own the tree and you don't own the wire, no, it's not a dangerous condition of your real estate. Now, you might have the right to take that tree branch off, but that doesn't mean that a trespassing tree branch is necessarily of your real estate. It's just that. It's a trespass. And so I think we have to be careful not to conflate, I think, the first prong, the subpart A, which is whether we have a duty and whether you can meet the traditional, test for negligence, and the subpart B question, which is this of the real estate as the General Assembly intended when it enacted the Sovereign Immunity Act? So we're here on a pure, I think, statutory construction analysis, not a common law negligence duty analysis.
But you're right in the sense that, I certainly understand where some of the justices are coming from. If we were looking at the statutory language in and of itself at this point in time and looking at of the real estate, you could say, looking at nothing else, if there is a trespassing rotting tree above my home, that's a dangerous condition for my home. Wait, now, just bear with me.
Sure.
I'm putting aside what I think is the problem for the other side's position.
Sure.
The problem is Snyder. Snyder already interpreted that language of the statute a long time ago and said when the General Assembly was saying dangerous condition of the real estate, they said the dangerous condition has to derive, originate, or have its source in Commonwealth real estate, Commonwealth realty. These hypotheticals about the bridge, the wire, the tree, are dangerous conditions, no question. But they're dangerous. The question is it a dangerous condition that emanates from Commonwealth real estate? Which is why I think Mr. Bashman was being very honest. He's saying, in order for me to basically win, I have to prove that the tree belonged to the Commonwealth.
Right. Yeah, I think that was all really well put, Justice Robson, and I agree with how you characterized it all and what the court said. And
we could overrule Snyder, I guess.
You haven't been asked to, and I know this court takes its precedent really seriously, and it doesn't typically overturn precedent without A, being asked to, and B, developed advocacy on that point. So, as I understand my friend's brief, he takes Snyder and all of this court's precedent as a given. And so I think in light of that, we have to effectuate that language that you read, which is, again, the load-bearing term in the real estate exception is of. It has to derive, originate from, or have as its source. So, the premise of our summary judgment motion was assume they can, prove everything else to a jury, including that the condition was dangerous. The only question is it of, meaning derive, originate from, or have as its source? And to make that determination, you look to the ground. And
Counselor, let's tease that out a bit.
Please.
Your argument is that the object must be attached to the ground. So, under the definitions, first of all, highways are construed as part and parcel of a Commonwealth real estate. 5822B4 extends and it describes the highway under definitions as quote unquote a way or place of whatever nature open to the use of the public as a matter of right for purposes of vehicular travel. If the definition of highway isn't premised on the literal road on the ground, how can we give 5822B4 such a construction that it requires something to be affixed when the General Assembly said it in a much broader term?
Right.
I'm confused because it seems your argument negates the definition of highway and your argument of immunity doesn't hold weight with regard to the definition.
I don't see any inconsistency, Justice Doherty. So, as this court said in Kagi, a highway is just another one category of real estate, that's covered by the act. So we're looking at whether it is of Commonwealth agency land, and so I don't think there's any inconsistency with how we describe PennDOT's, overall obligation over the highway. But then when we're looking at the specific waiver, it has to be of the real estate itself. And the way this court has interpreted that phrase is it has to be affixed to the land. And so I don't see any tension between those two concepts. And as this court identified both in Kagi and Wise, we're not going to presume that Commonwealth agencies act irresponsibly when it comes to the safety of the highways. But again, we have to effectuate the intent of the legislature in enacting the Sovereign Immunity Act, and the purpose there was to limit our liability unless you fall into the four walls of the exception itself.
Counsel,
So I hope I've answered your question, but
Counsel, here's, and this is really in follow-up to Justice Doherty's question. Here's my problem. The source of the problem here with notice of that overhanging rotted leader, the source was allowing the roadway to remain open. That was the source of the danger that existed here. With knowledge of that overhanging leader, the source of the issue is of the Commonwealth's property, i.e. maintaining the roadway operational.
yeah, I mean, I suppose I see source as sort of a synonym for like derive, originate from, or have its source. And I think, again, for source, it means...
Seeing the trunk of the tree.
Yeah, I think to determine the source, you have to look at the base of the tree because, as Justice Brobson alluded to earlier, a tree can't exist out of thin air. It has to be affixed to the ground somewhere. So I don't think
Except the overhanging leader here was ultimately not the actual source of the injury here. The actual source of the injury was PennDOT allowing its roadway to remain open with knowledge of that danger. So it was allowing the traffic to continue to travel in that area. I mean, I see your definition or use of the word source to be more limited so as not to capture what actually happened here. I mean, had the roadway been closed, we wouldn't be here.
I appreciate that, Justice Donahue.
And so, it is the real property that is at issue here. It wasn't maintained in a fashion that made it safe for the intended use.
Right, but as the arborist report suggests, it wasn't maintained by SEPTA, the owner of the tree. And, I think we can't work backwards from the sort of happenstance of like the exact point where the tree fell.
You can if PennDOT had knowledge of this issue of their property. That portion of their property was dangerous as a result of the overhang.
Again, I think in a trespassing or encroaching condition that originates from another property or has as its source another property.
Let's change the facts. Let's say the tree fell down.
That's all I got.
And and PennDOT was aware there was a tree in the middle of the road. And someone got injured by hitting the tree in the middle of the road. Is that now the road has a dangerous condition because of branches in the road?
No, I think still the source of the tree is non-Commonwealth land. I mean, if we
that's Jones, right? Jones is the rock salt case.
Correct.
And we basically said that the rock salt did not derive from the real estate.
Correct. So it has to derive from the land itself.
Right. So the shutting down of there was no duty to shut down the train platform in Jones.
No.
Just put aside the duty question.
Yeah.
There was no liability.
Correct.
For the dangerous condition of the platform by virtue of the rock salt.
Right. The salt didn't derive from the land itself, just as a tree sitting on the ground doesn't derive from our land itself. It derives, in this case, from SEPTA's land, which I'll note is also a Commonwealth agency here, so it's a sort of quirk of this case. But I think it is telling that they haven't moved for summary judgment. They haven't participated in this case. And, if my sort of friend's theory of this case is to be believed, they're not on the hook at all because there was no dangerous condition deriving from their real estate. But of course, they are still here because the base of the tree was firmly situated in SEPTA's property. That's who was responsible for maintaining the entirety of the tree.
It have to be either or. You maintain it has to be either or. It can't be.
It doesn't have to. There can be joint liability, but I think in this particular case, because the base of the tree in its entirety was situated on SEPTA's land, it's responsible for it, not PennDOT. You can have situations where perhaps it sort of goes down the middle of the property line and the base of the tree is situated in both, and I think there you would sort of engage in a joint and several liability analysis. But so it doesn't have to be, but in the context of this case, it is.
All right, thank you, Mr. Mullen. Let's hear from Mr. Selak.
Thank you.
Good morning, all. May it please the court, Michael Salick here on behalf of Upper Merion Township.
Could I ask you, counsel, normally when you settle a case, you don't want to have anything to do with it, you're done with it. I mean, putting aside the issue of can you be here, why do you need to be here?
So the township's interested in this to the extent that this ruling will be used in the future to argue any expansion of tree liability in the governmental immunity context. So there's
It's a totally different statute. I mean, they're here under the Sovereign Immunity Act, and you're talking about the Tort Claims Act under a totally different statute. And you have the word trees in your statute. They don't have the word trees in their statute.
Correct, Your Honor. So there is case law out there that says the two immunities can be interpreted consistently when addressing the same subject matter, i.e. trees. So the township believes, I believe that there's a possibility that if this issue crops up again in the future, this ruling will be held, even though it's a sovereign immunity matter, I get that, will be used to argue for an expansion of tree liability in the governmental immunity context.
You don't believe you already have greater liability? Your immunity is lessened for care, custody, and control?
I'm sorry, Your Honor, I didn't catch the first part.
You don't acknowledge that your immunity is less protection than the Commonwealth because you have care, custody, and control liability, or lack of immunity there?
I'm not sure that I would agree to that. I think what concerns the township in this case is the fact that this ruling could be used in the governmental immunity context. I think the case law is pretty clear that the two immunities can be used one way or the other when addressing the same subject matter.
Because is your concern that if the floor is raised here for Commonwealth liability, that necessarily raises your floor?
Oh, my concern is that what appellants are asking for is an expansion of tree liability, a broad interpretation of tree liability, contrary to the directives of the court. And I think that's a very dangerous result that we have to prevent, that I think the Commonwealth Court astutely ruled to prevent. And so that's my concern. And that's why I'm here, and that's why I submitted the brief. Does that answer your question sufficiently? All right. So for many of the same reasons that were set forth by Mr. Mullen, the township agrees and believes that the Commonwealth Court's ruling should be affirmed. I'm not going to repeat all of those. I am going to hit on a couple nuances that are specific to governmental immunity and for the township. Okay, and I'll keep it brief because I know that this is batter number 2 here on this argument, so I'm cognizant of that. In listening to all of the arguments today, but obviously this one, there are a lot of issues that are involved in this appeal. Some more important than others, some more relevant than others. I tend to look at things, try to boil them down into the crux of it, the bottom line, what we should focus on. And in this case, what we can't lose sight of the fact is the directive from Pennsylvania courts that both of these immunities, but particularly governmental immunity, need to be narrowly construed, narrowly interpreted. Okay? And the only way to do that with this issue, the only way is to draw the line of tree liability at the right-of-way. If we expand tree liability to include trees whose bases are outside the right-of-way, whose branches sprawlingly make their way over other people's properties, to me that is a very clear way to broadly interpret this immunity, something we cannot do. So the only way to narrowly interpret it is to base it on the tree trunk, on the tree base. Where is that? And it's got to be within the right-of-way. Beyond that, then, we are in a Commonwealth with a lot of trees and a lot of roads that are flanked by a lot of trees. We are expanding municipal liability to now include these trees, hundreds of thousands of additional trees, as part of their liability. And I think we all know what that's going to do is it's going to increase the cost of these municipalities to maintain their roads They're going to have to retain arborists to now drive these roads and look for any branches, regardless of where the tree is located, regardless of who owns the tree. All of a sudden now municipalities need to retain arborists to look for branches of others.
Why? I don't know if this is too granular, but why is that parade of horribles attendant here? Isn't the issue not retaining an arborist, but simply reporting up the chain of command when notice is given about a dangerous tree, as could have happened here?
Doesn't take an arborist to know there are branches.
Oh, yes, I was just...
Somebody drove through, right? So here, notice was given, and somebody did drive through, it just remedies weren't undertaken.
Yes, I was just giving that as one example of how the cost on municipalities would go up. Obviously, the liability would increase, and premiums would go up and all that. That was just one example. But the reason why I gave that example is because that flies directly in the face of the legislative intent and the objective of immunities, which is to limit liability and limit costs and limit the taxation on the public treasury. And so that was, Your Honor, I understand your question now. That was just one example of how it would fly in the face of that objective.
Okay, I think we understand. Thank you very much.
Thank you.
Thank
Yep.
you all. Mr. Minner, court will take a lunch recess until 12:30.
Court is in recess until 12:30. Back in session, please be seated.
Oh, good afternoon. You've done a great job at clearing out the courtroom. Would you call the next case, Mr. Minner?
Commonwealth of Pennsylvania versus George Bloomer, representing George Bloomer, Mr. Sosnoff, representing Commonwealth, Mr. City Trustee.
Good afternoon.
Good afternoon.
In this case, appellant was convicted of the summary offense of harassment and sentenced to 45 to 90 days in prison. Following the trial court's denial of his motion for reconsideration of that sentence, he appealed to the Superior Court, challenging the discretionary aspects of his sentence. The Superior Court held that it lacked jurisdiction to consider appellant's claim because Section 9781 of the Sentencing Code provides for the filing of a petition for allowance of appeal of the discretionary aspects of a sentence only with respect to felonies or misdemeanors. We granted discretionary review to consider two issues. First, whether the Superior Court erred in concluding that under Section 9781 it lacked jurisdiction to consider appellant's challenge, and second, if the Superior Court was correct, whether appellant had a constitutional right to appeal the discretionary aspects of his sentence under Article 5, Section 9 of the Pennsylvania Constitution. Please proceed.
May it please the Court, Leonard Sosnoff for Mr. Bloomer, and I'm here with my co-counsel, Alexander Ward. I'll focus today of my argument on the constitutional issue, which was not considered at all by the Superior Court with their sua sponte decision. 9781 has been around for almost 50 years, but longevity doesn't make it constitutional under the Pennsylvania Constitution. Commonwealth versus Lee is a good example of that, very recent decision of this court, invalidating on cruel punishment grounds under the Pennsylvania Constitution the second-degree murder sentencing statute, which had been around for perhaps more than 50 years. The text of this statute is plain and unambiguous. I mean, the text of this constitutional provision, Article 5, Section 9, is plain and unambiguous. It says there shall be a right of appeal, and then it says from a court not of record to a court of record, et cetera, and it also expressly limits the role of the legislature at the end of the provision, besides providing the right to appeal. The legislature's role in this whole scheme is the selection of such court to be as provided by law, and there shall be such other rights of appeal as may be provided by law. There's no authority to constrict the absolute right to appeal, and I use the word absolute because that's the word this court has used more than once. About 4 different decisions talk about the absolute right to appeal. And the issue today is not even one of first impression. Commonwealth versus Stock was a case where a defendant wanted to appeal his summary conviction and sentence. And the question was, could he claim ineffective assistance of counsel? This court, in a unanimous opinion, held, of course he can claim ineffective assistance of counsel if he had counsel, because that's the only way. He had asked his counsel to appeal, and he had a right, at least 3 times in the decision, he had a right under Article 5, Section 9 to appeal his summary conviction and sentence. And therefore, he had a right, if he had counsel, that counsel had to provide effective assistance to counsel. The Commonwealth makes no argument on the text at all, except to say, well, it doesn't expressly say that the legislature can't limit or eliminate appeals from summary discretionary sentences. That argument holds no weight. constitutional provisions are usually a couple sentences, sometimes one sentence. They don't spell out every circumstance. There may be 50 different circumstances under the law where the standard is abuse of discretion on appeal. And there's no list of 50 that will be provided under a constitutional provision. And the fact that this one doesn't appear specifically delineated at the end of the provision means nothing. In fact, if the Commonwealth was right, nobody would have the right to appeal in any situation, because Article 5, Section 9 doesn't list any specific situation where there's a constitutional right to appeal. Really, since there is no textual argument, and this court has held repeatedly it's an absolute right to appeal under this section, and Stock, when the holder's a right to appeal in a summary case, a conviction means not just trial or pled guilty, but your sentence.
So, counsel, your client has the right to 2 appeals.
Pardon me?
Your client has the right to 2 appeals, correct?
Well, that's the way the constitutional provision is written, to provide it that way. It does not have a right. He has a right to go to an appellate court. That's what's clear from the constitutional provision. He does not have a right, for example, 9781 is constitutional to the extent that it provides that in Section F, you don't have another right to appeal to this court. It can be limited to one right to appeal to an appellate court after a court of record, common pleas court. And that was the situation, by the way, in Stock. First before district justice.
Stock went from an MDJ to, and the appeal was to the Court of Common Pleas, and that's what he was denied in that case. It wasn't the right to an appellate court review.
Then I stand corrected for that factual difference from what I just said. But it has been interpreted to mean a right to appeal. It includes an administrative agency. It has a right to appeal to an appellate court, not just a trial level court.
Well, and really, can you think of any other situation where the right to an appellate court from a Court of Common Pleas is limited? I mean, take, for example, a civil case that starts before an MDJ. That civil litigant has the right to an appeal to the Court of Common Pleas, and from there, that civil litigant has the right to an appeal to the Superior Court.
Yes, that's
I'm just trying to think of another situation in which this right to appeal to an appellate court is limited, and I couldn't think of one.
Either could I. I mean, this is sui generis, really, what the legislature has done in 9781 in trying to limit a constitutional right to appeal. And really, the text alone should be dispositive. This court had Yard a couple of years ago about right to bail under the Pennsylvania Constitution. The Attorney General even had interpreted it in a way that favored the defendant as a life sentence prisoner. And this court said, we are not at liberty to ignore the plain language of the text of the Constitution. In that case, the bail provision. That really should be the end of deciding this case. But I will go on because this is a case where also, if there was any ambiguity at all, there's a complete marriage between the text and the legislative history. The legislative history, and there's only a couple pages set forth in the brief with citations to what happened at the convention that led to Article 5, Section 9 being adopted. The whole purpose from the people who initiated the amending of the Constitution was so that people in summary cases and zoning appeals, that was the initial momentum for having this. And the whole thrust was to change what had been before, which was, one, there was only a right to appeal under the Pennsylvania Constitution for felonious homicides, as far as criminal cases. But there was another constitutional provision that said you could do summary appeals if cause was shown. And one of the main purposes of this provision was to take out that you had to show cause to the appellate court before it would hear your case. That was one of the main reasons for the adoption of Article 5, Section 9. There's more legislative history than as far as the debates that went on before this was adopted, but it is exactly to prohibit what 9781 does. Substantial question, it's not much different from cause shown. And this even goes further as far as 9781 provides really the exact same procedure that litigants have to go to ask this court to hear a case after it's been heard in intermediate appellate court.
Counsel, can I interrupt you for a second? I'm trying to avoid, I guess, the constitutional question if I can avoid it, but does the sentencing code even apply here with regard to these summary dispositions, these summary charges?
Yes.
Which section of the sentencing code dictates the sentence that had to be applied here to the trial court?
Pardon me?
Which section of the sentencing code dictates the sentence that the trial court had to apply here?
Do you mean as far as a judge, as far as...
Minimum, the maximum, the particular crime at issue or offense here at issue?
Well, there's a statute, Section 1105 of Title 18, that says the maximum sentence shall be 90 days.
I'm talking about the sentencing code, though.
So I'm about to get to that.
Okay.
Okay, so 9721 provides all the factors a judge must consider at sentencing. 9722 provides all the factors a judge must consider for an order of probation.
And you're saying that that these all apply to
Summary cases.
summary cases?
Yes, they're not excluded at all. They're not excluded in any of the provisions. 9721, 9722, you can go to partial confinement, you can go to total confinement. Every provision is generally, and of course it has to be that way. It would be an absurd, unreasonable situation if judges were permitted to send people to jail under any circumstance, summary cases or otherwise.
What was the charge here?
Harassment.
Okay, and you said 9720 was the sentencing code, one of the sentencing code provisions you said would apply?
I'm saying that basically 9721 is the general one first. Then there's 9722, which talks about probation. There's 97, I might remember the numbers wrong, but total confinement, partial confinement. And the judge wrote an opinion in this case. Until this case, until the court sua sponte in Bloomer decided that a judge doesn't have to give any reasons for a sentence because it doesn't matter, there's no appeal. The discretion. A judge can abuse discretion at will is the bottom line here if there's no protection. This judge, because it was pre-Bloomer in the lower court, wrote an opinion, given his reasons, talking about the sentencing code, why I considered this, why I considered that, and why I, in the end...
Share with us, under 9781B, the word summary offense is not included.
That's correct.
Now, why is it not to be deemed that the General Assembly, within their right, excluded it just as well as the fact that a summary offense doesn't have a right to a jury trial because it's considered a petty offense? And that's a constitutional. They do not have a constitutional right to a jury.
Correct.
So if we're denying them a constitutional right to a jury, why can't the General Assembly deny them a right to an appeal pursuant to 9781B?
Because of Article 5, Section 9. You have a constitutional right to appeal, and that means a decision on the merits.
That's a trial in Philadelphia would be a trial de novo to the Court of Common Pleas. That's the right to appeal.
First right.
Or in Philadelphia to be a right to appeal to de novo, and then there's a right to appeal to the appellate court. Like I say, this statute, the legislature wasn't given the power to limit that people can't, in summary cases, have a right to appeal. It's just not been given to the legislature, and this court held it in stock. I mean, I'm not making a real novel argument here. And like I said, the legislative history supports that litigants don't have to show cause to be able to appeal a case to the Superior Court or the Commonwealth Court. If the legislature can do that here, they can do it with a sentencing statute that reaches beyond summary cases and just says abuse of discretion can't be appealed. The sentencing discretion can't be appealed unless you show a substantial question. There's no limiting principle. They could have a statute that says anytime there's an abuse of discretion claim, for example, continuance in a case, whether evidence was properly admitted, a litigant cannot appeal unless they show there's a substantial question. There's not a limiting principle for what the legislature has done here. And as I said, the legislative history, if there's any room for ambiguity, and none was raised by the Commonwealth, but if there's any room for ambiguity, the legislative history is clear as day. The only argument they make is, well, the McFarland case from the Superior Court en banc, 5-3 decision in 1989, the McFarland decision said two things. One, you could have reasonable regulations of appeals. The legislature, that's true. You can regulate the manner of appeal. You cannot limit review of the merits. So the one case that McFarland relied on, the case that they quote for 3-4 pages in their brief, the one case that McFarland relied on was the 1879 decision of this court, Commonwealth versus Sayre. And the issue in Sayre was a felonious homicide, first-degree murder case. And I think he was sentenced to be hanged at the time. And the issue at the time was a legislature said you must appeal from your judgment of sentence within 20 days. And this court held that is a reasonable regulation on the manner of taking an appeal. It does not, unlike 9781, limit the merits at all. It's the analog of our 30-day rule now. And the court said in Sayre, a litigant doesn't have a right to appeal whenever he feels like. He might be on the gallows about to be hanged and says, oh, I'm filing an appeal, don't hang me. That's a reasonable regulation. Rule 302 of the Pennsylvania Rules of Appellate Procedure. You waive issues if you don't preserve them in the lower court. That's reasonable. Litigant doesn't have the right to raise any issue in any manner. But Article 5, Section 9 is the converse of Rule 302. If you preserve an issue, you have a right to review on the merits. That's constitutionally guaranteed. The only issue that is raised by the Commonwealth is actually a policy one, and I'd like to address that. They argue, and this is part of the McFarland decision from the Superior Court en banc, the majority. If we allow this, it will clog the courts. And there are several problems with that argument. First, policy cannot override a constitutional provision. And this court has held that many times, even in cases where the consequence, being faithful to the Constitution, might produce some danger to the community. Cases like Commonwealth versus Alexander, Commonwealth versus Hicks. Policy cannot trump the rights guaranteed under the Constitution. That's first. Second, it's totally contrary, as I said before, to the legislative history of the case, because while this was being debated, some of the legislature said, wait a minute, this is going to clog our courts. And the ones who advocated for Article 5, Section 9 said, even if that happens, we don't think it'll happen, but even if that happens, we're talking about fundamental rights here. And it passed with only 2 dissenting votes in the end. So the whole business of trying to amend this because it'll clog the courts that was already considered when this was promulgated. Empirically, this will not flood the courts either. There's no support for flooding the courts, and that's for two fundamental reasons, I think. One is that until Bloomer, sua sponte, decided that you cannot appeal the discretionary aspects of a summary appeal, there weren't that many appeals. We know the court won't be inundated if it's recognized that there's a constitutional right to appeal, because we know it up until Bloomer, this case. The other reason is, when we're talking about summary cases in particular, as far as appealing a summary case, most defendants aren't going to appeal because of the cost involved. If they got a very short jail sentence or a fine, the cost of pursuing the appeal is a big deterrent. And also, if they want to have some chance of winning, they should have a lawyer, and that's a big deterrent cost-wise. So it's just not going to happen. And I want to comment on one thing further about judicial economy in the context of this situation. Right now, judges have to go through several factors to decide whether there's a substantial question, a whole pre-analysis of the case to decide whether, in its opinion, it wants to allow the case to proceed to the merits. And again, Article 5, Section 9 is written totally discretionary. Even if there's a substantial question, it says the court may hear the appeal. It's not even required to. But you have to go through all the substantial factors and write an opinion, considering the factors, and again, decide whether it has any merit. That is, as some judges have expressed before, including the dissenting opinion in McFarland, a waste of judicial time. Get to the holding. It doesn't have any merit, rather than go through this rigmarole. And I want to refer to one case, just as an example of this, what the system produces, and that's Commonwealth versus Zirkle, a decision from the Superior Court in 2015, where Justice Wecht and a judge authored the opinion. There's about 2 or 3 pages dealing with the issue of whether there's a substantial question. In other words, seriously addressed, just like the legislature said, to go through the whole rigmarole before deciding. The decision in the end was, this is really an incredibly weak argument. It doesn't even merit our merit review. That could have been arrived at if you were not bound by this statute. That could have been arrived at in a paragraph based on past precedent. And in that case, the other reason I mentioned Zirkle is because Judge Strasburger wrote a long concurring opinion, and he stressed how it is unconstitutional under Article 5, Section 9 for a court to refuse to entertain an appeal on the merits with an issue that's properly preserved.
Counsel, can I?
And you responded by saying, I'm sympathetic to what Judge Strasburger has said, but I'm bound by precedent, and I'm bound by the statute. There wasn't a constitutional issue raised.
Counsel, what is your client asking for in terms of a result in this case? Because your client's charge is completely excluded from 9781.
Pardon me?
Your client's charge is completely excluded from 9781.
Correct.
So what does your client want in terms of?
He wants it declared unconstitutional, 9781, because he has a right to appeal.
Well, but he's excluded from it.
That's a statute. The statute's unconstitutional, so since the statute's unconstitutional, the only question is, what is his relief on remand?
Not that Article 5, Section 9, the right to appeal from a court of non-record to a court of record. Why is that not sufficient? Such that that's what the Constitution permits based upon summary offenses, and it restricts it under 9781 to not include summary offenses. I'm confused that where you think you have this continual constitutional right when the constitutional right provided by 5.9 is your right to appeal to the Court of Common Pleas.
Well, first of all, that would require, I don't think that's what the text provides, given all what it says about the right to appeal.
How does it plainly, palpably violate the Constitution if the right to appeal is permitted in summary of cases by going from a court of non-record to a court of record, AKA you got your constitutional rights, and the government, the General Assembly, has the right to determine what authority we judges have, and they did that through 9781.
I don't believe they can exclude summary discretionary sentences.
Tell me how it plainly, palpably violates the Constitution when we have embedded constitutional rights in it. You may not like them, but that's what the Constitution permits.
Okay, this is what I'll say. The error here, the error of law that was committed was by the Common Pleas Court.
Right, but you still didn't answer my question.
No, I'm trying to answer your question. It abused its discretion in sentencing is the claim. And since it abused its discretion...
How did it abuse its discretion? By following the statute?
No, we make allegations. The statute permits no appeal at all from the Common Pleas Court judge. In other words, if there's no right to appeal for what the Common Pleas Court judge did, that's right, if there's no right to appeal, that means, and this would be to me a distortion of the legislative history and the language, that would mean a judge in a summary case in a Common Pleas Court could abuse discretion at will, does not have to give any reasons, because you couldn't appeal to the superior.
If that's the court of final review, that's similar to saying if you lose here, what do we do? We're violating your rights because we disagree with you?
I think the difference is, and I'm not expressing it well, I think the difference is an appellate court. In the summary case situation, it is not functioning as an appellate court. It's de novo. So because it's de novo, it's a completely new situation. The first appeal is from the Common Pleas Court decision. The decision of the district justice is wiped out by trial de novo. That's one of the reasons that rights are sometimes limited with the district justice, because you are entitled to a trial with more rights in Common Pleas Court. And that is the decision. The first level of appeal from the Common Pleas Court is the Superior Court of Pennsylvania.
Well, in that
that's
context,
what can't be eliminated.
If I understand, counsel, in that context, you're referencing the second clause of the constitutional article, and there shall also be a right of appeal from a court of record, blah, 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 to a court of record or to an appellate court. Isn't that what you're referencing in response?
Yes, I'm also referencing the holding of this court as far as Article 5, Section 9 in the Stock case. It's a right of appeal. And in that case, I know that
you're mixing apples and oranges there. This is the discussion we had early on. I happen to agree with your argument, but I mean, you're now talking about the first sentence, there shall be a right of appeal in all cases to a court of record from a court not of record. That's your client's first right of appeal. It doesn't matter that it's a trial de novo. Constitutionally, your client is entitled, that is called a right of appeal in the Constitution, from the magistrate judge to the Court of Common Pleas. He's also entitled, under the second sentence, a right of appeal from that court of record to an appellate court.
Yes.
I mean, and that was my first question. I mean,
yes,
your client gets two appeals. I said, is that correct?
They're different.
Well, but they're appeals according to the Constitution. And I asked you the question, is there any other circumstance that you could think of where we limit the right of an appeal from the Court of Common Pleas? Like, and for example, magistrate district judge hears civil cases. That civil litigant has a right to an appeal to the Court of Common Pleas. There's no question that that civil litigant has a right to an appeal to the Superior Court from that Common Pleas Court decision, correct?
This is sui generis. There is no other situation that I know of.
That was my early question, because I think it's easy to say you get one appeal. Well, your client had one appeal from the magistrate district judge to the Court of Common Pleas, but that's not what the Constitution says. The Constitution says there's another right of appeal.
And I would say that that would be an excessively literal interpretation of the constitutional provision, which again, if it was ambiguous, all the legislative history is against such an interpretation, because giving somebody a trial de novo means it's a brand new situation. It's not an appeal in the traditional sense of an appellate.
That's not what the Constitution says. The
No,
Constitution calls what happens in that circumstance a right of appeal.
I would say that if that was the holding of this court, that the defendant loses because he had a right to appeal.
No, I think you're missing. I think Justice Donahue is trying to help you.
I'm trying to
There's
help
two rights of appeal.
I really am trying to help you. I mean, I think it's
you are
somewhat
helping me.
intuitive.
I know you're helping me. I'm just trying to.
She's giving you the argument that
I mean,
She's answering Justice Doherty's question.
you know, frankly, I mean, you know, my first thought was, well, he had a right to an appeal to the Court of Common Pleas. But that's not what the Constitution says. The
I know that,
Constitution
because
says he then has a right of an appeal from that to an appellate court.
Okay, so if let's say we literally interpret it. I'm trying now to use your help and go another step. Let's say you had a right to appeal from magistrate to a common pleas court, and then you had no right to appeal further, period. In other words, that would be the interpretation. You have no right to appeal.
No, that's not what Justice
Not what
Donahue
I'm
was
saying.
saying at
I'm saying
all.
exactly the opposite.
She's arguing your case.
I'm saying exactly the opposite.
Except in Article 9, Section 9, it says the selection of such court to be as provided by law, and the law that restricts a summary appeal is 9781, because that too is in the statute, and we got to read the statute together. We just can't separate it. It has to be read. The specific language is the General Assembly gets to permit which courts individuals have a right to appeal, quote unquote, as provided by law.
But Justice Donahue is reading from the Constitution.
An appeal to an appellate court, the selection of such court to be provided by law. So it could be the
They
Superior
can call it the
Court,
Superior Court, they can call it the Commonwealth Court, they can call it Veterans Court. They can't.
Or they can restrict the right to appeal after its right to appeal in the Court of Common Pleas.
So this would be an unreasonable interpretation of the Constitution, because that would mean that anybody convicted in common pleas court, when it's,
No. If you're charged in the Common Pleas Court, you have a right to appeal. If you're charged in a summary court, the magisterial district...
that's the whole issue here.
I know what the issue is.
You have a right to appeal.
I don't agree on it.
What? Pardon me?
We just disagree as to the reading of the constitutional provision.
If you have a right, if there was no right, I hope I'm paraphrasing correctly, if your right under Article 5, Section 9 is completely fulfilled by going with the right of appeal from the district court de novo to the common pleas court, what that would mean is an unreasonable interpretation of the Constitution, because what that would mean is when you had that trial de novo, a judge could do whatever he or she wanted, could violate the law, could abuse discretion, and there would be no recourse. That can't be the meaning, as far as this court always says with statutes, it can't be an absurd or unreasonable result. That would be totally unreasonable.
If it's a policy decision by the General Assembly to view summary offenses as not being... I may disagree with it. Maybe the General Assembly doesn't believe 90 days in jail is that extreme, such that it doesn't, your constitutional right doesn't attach. I don't know. That's the policy of the General Assembly. All I know is that's what 9781 excludes summaries, and by the operation of law, it cannot be applied pursuant to Article 5, Section 9.
And
Why is that not a fair reading? Because you
it's a,
disagree with it.
no, that may be a fair reading of the statute. I leave that to my
No,
brief.
this is the Constitution I'm reading, but applying the statute to the Constitution.
Applying the statute to the Constitution would mean if the legislature thought summary cases, somebody going to jail, and maybe this was the intent that people going to jail for 90 days is not that important. So we're not going to give them the right.
That's when you have to spend time in jail.
I know that. I know that very well.
I agree with you.
Counsel, can I go back to my question about what you're asking for? So you're saying you just want us to wipe 9781 off the map, but your client's charge is not within 9781. Why do we have to touch that? Why can't we just say your client has a constitutional right to an appeal, 9781 doesn't address your client's situation, we'll leave 9781 on the books and we'll just say you have a constitutional right to an appeal. Take your appeal. Why do we have to strike 9781?
You could say that. The question would be, what would be the relief for this defendant?
The relief is you get an appeal to the Superior Court.
The relief would be that he's entitled to a merits decision in the Superior Court.
Right.
That's what the remand should be here.
Well, that's what
Then you can leave 9781.
Well, that's what I'm trying to understand is do you believe that we must, if we agree with you, do you believe that we must strike 9781?
I don't think you must, but logically, it probably would be the best course to take. Because if you leave 9781 intact, and my client with a summary case, remand order, Article 5, Section 9, you must decide the merits of this summary appellant's discretionary aspects of the sentence, then summary litigants will have more rights as far as on appeal than those in felonies and misdemeanors. And the court could do that if you don't want to touch 9781. But I think logically, the best course is to consider 9781 on its merits, because otherwise, as I said, the only relief under the Constitution should be a remand for the merits of my client's appeal, not whether it's a substantial question, not a pre-merits decision before the merits under Article 5, Section 9, but a decision on the merits.
But you're not asking for us to shoehorn your client into 9781. You're just saying, my client has the right to appeal to the Superior Court, period. It was the Superior Court who shoehorned this case into 9781.
So there is an argument in the brief about statutory construction saying you can shoehorn summary cases into 9781. And that's referring to several principles of statutory construction. However, I recognize there's a strong argument on the other side. As far as 9781, it doesn't include the word summary appeals, and it talks about the guidelines. So the statutory construction issue in this case, I could go through very...
That's all right. We get it. We got it. We get it, and we got it. Thank you, Mr. Sullivan.
Thank you.
Appreciate it. Let's hear from the Commonwealth. Attorney Tressler.
May it please the court, I'm Lisa Tressler from the Northampton County DA's office, representing the Commonwealth.
Could you speak up a little, Counsel?
Or bring the mic down a wee bit.
Yeah, there you go.
Can you hear me better now?
Yes.
As much as Justice Dougherty's arguments favor my side, I, in candor, must say that the Commonwealth agrees that under Article 5, Section 9, all defendants, including those in summary cases, have a constitutional right to appeal the judgment, which includes the sentence. The Superior Court did entertain his appeal. They decided his evidentiary question. They decided his sufficiency of the evidence question. They just said, we can't hear your pure discretionary aspects of sentence question. So you have to look at what the Constitution intended to create when it created this provision saying you have a right of appeal. There is a huge distinction between appeals for legal error and appeals that are purely about the way a sentencing judge weighed permissible.
I don't know what you're talking about, this purity concept. I mean, most appeals are not that he exceeded the statutory max, but some species of abuse of discretion. So I'm not familiar with this whole area of purity of whatever, the vast majority of cases are going to challenge some aspect of discretion.
Correct. But
So if you're right about your argument here, as I'm flipping through your brief, I'm wondering if you're right, what would stop the General Assembly from tomorrow from just eliminating appeals and discretionary sentence for anything?
Well, at the time that the Constitution was passed, this provision was passed, it was common for courts to hear appeals based on abuse of discretion, but they defined abuse of discretion in terms of a legal error. Illegal sentence, jurisdictional defect, violation of the rules of evidence, insufficient due process claims, insufficient evidence, judicial bias, federal constitutional violations, equal protection. So it was not commonplace at that time for a court of appeals to say there's no legal error, this sentence was not infected by any legal error, but we are going to, as an appellate court, we're going to look at the sentencing factors that the court considered, and we're going to reweigh them. We're going to say, well, he didn't give enough importance to this factor. He gave too much importance to that factor. That is something that historically had not happened, even when a court of appeals was saying that the sentence was excessive. They usually...
Commonwealth. The first issue is, did Superior Court err in holding that it lacked jurisdiction to consider the discretionary aspects of petitioner's sentence under 9781B of the Sentencing Code? What's your answer? What's the Commonwealth's position?
No, they did not err. When they first passed the constitutional provision, this whole question of allowing appeals that were strictly about how a judge weighed factors in an otherwise lawful sentence, that wasn't part of the legal landscape. It wasn't stated in the constitutional provision that they were going to suddenly open up a whole new class of appeals where they were going to reweigh what a sentencing judge had done in terms of the factors.
Commonwealth's position with question 2, does the petitioner have a constitutional right to appeal the discretionary aspect of his sentence under Article 5, Section 9?
As long as you define abuse of discretion as what they were looking at when they passed Article 5, Section 9, which was some violation of some legal principle, not just simply reweighing how much weight the judge gave to various
I don't understand that at all. That doesn't make...
A right to appeal.
An illegal sentence, or you have a problem with the discretionary aspects of sentence. I'm not sure what you're saying.
Well, where does the Constitution draw the distinction that you're drawing?
It didn't say it in so many words, but it didn't address the issue at all.
Well, sure it did. It says you have a right of appeal.
But in Judge Papadakos' dissent in McFarland, he pointed out that at the Constitutional Convention, the concern was about legal errors and insufficient evidence. That was the concern. It wasn't, we think that people who have had a sentence where the judge weighed permissible factors should be allowed to go to the Court of Appeals and have them reweigh all of those factors and substitute their judgment.
You seem to be raising, it's almost a justiciability question. You seem to be saying that when the General Assembly passed the Sentencing Code and made this limitation, they purposefully didn't want appellate courts substituting their judgment for the judgment of the duly elected common pleas court judges who were doing the sentencings, and only to examine the legality of it, because the General Assembly set forth the Sentencing Code to tell judges how to sentence people.
The General Assembly did, in the Sentencing Code, create a body of law for the precise purpose of influencing a judge.
But am I correct in the idea that really what you're saying is the General Assembly made a policy decision that when we created the Sentencing Code, there is nothing to appeal when it comes to a discretionary aspect of sentence, because as long as it is within what we say they can sentence, we don't want appellate courts to second-guess common pleas court judges.
Only within the parameters of the Sentencing Code. and the specific, very carefully circumscribed.
It's not the same as an abuse of discretion, as we would like an evidentiary ruling or something like that. Discretionary aspect of sentence is different from abuse of discretion. That seems to be what you're arguing.
Yes.
Well, I don't follow that at all, but I still want an answer to my question. If you win this case and we affirm the Superior Court, what I want you to tell me is what prevents the General Assembly from repealing 9781 tomorrow and just eliminating all appeals in all discretionary challenges. There's no principal distinction that I see here.
They created it in the first place, is what I would say, Your Honor. There was no such body of law before then.
Okay, so I appreciate that. So I think your answer then is that if you win tomorrow or today, the General Assembly could just repeal 9781 and there'd be no challenge to discretionary aspects of sentencing in the Commonwealth, period.
If it was purely discretionary aspects of sentence and
Again,
not
this
legal
purity,
questions.
This purity concept is one I've never heard of.
What would you consider if they repealed 9781 tomorrow? Why would you say there's no bar on, or any limitation on, want to raise a sentencing issue to an appellate court?
If it's just about how the court weighed the sentencing factors.
As opposed to illegality of sentence.
As opposed to illegality, jurisdictional defect, violation of the rules of evidence, violation of a constitutional principle. There's lots of ways that violations of the law came to be viewed by the courts and described by the courts as abuse of discretion. But they were not talking about, and in fact, they often said, we're not going to disturb a sentencing court's weighing of the factors as long as it didn't violate any law.
But Justice Mundy's hypothetical was if 9781 went away, you're suggesting there would be no appeals of discretionary aspects of sentence. The exact opposite is true, because 5101 of the Judicial Code would give them a right of appeal for everything.
Right.
This is a limitation. 9781 limits the otherwise general right of appeal in the Judicial Code.
In the Judicial Code.
Which would apply, but for the fact that this is more specific.
Correct. But
so if this went away, all of them would be appealable, none of them.
well, I would just say that as historical matter, in terms of what the courts have held, it was never appealable. It was not commonplace at all for the courts of appeal to reweigh legitimate sentencing factors.
If the plain language of the statute is clear, we don't really go to the history. And as I read 9781, it's a limitation on appealing solely the discretionary aspects of a sentence for a felony or a misdemeanor. If you want to read 9781 and the Constitution together, it just means that summary offenses can do whatever they want with regard to their appeal, and they have a right from non-record court to record court, from record court to an appellate court, and they aren't bound by the limitations of 9781.
They're not bound by the 9781 limitations. They're bound by the state of the law prior to the time that the sentencing guidelines in 9781 were the first time that the legislature tried to create a body of law that would direct the judge how to weigh purely discretionary aspects of sentence as opposed to legal questions. And they, since they were creating it, it's a jurisdictional statute, at the same time they created it, they placed limitations on it because they didn't want, it wasn't about clogging the courts so much, it was about, historically, we did not want appellate courts to revisit the decisions that were made by a sentencing judge.
At least in my mind, is there's a difference between limiting an appeal versus totally barring an appeal that our Constitution provides for.
They don't bar an appeal for summary sentences. I mean, he says they do, but it doesn't. They did hear his appeal. They just didn't hear the discretionary aspects of sentence part of his appeal.
What if that's the only issue on appeal?
Excuse me?
What if that's the only issue on appeal? What if it was a perfect trial, and the only issue is, I think the trial court judge abused their discretion in putting my sentence, I wanted the Superior Court to look at what this judge did. This is egregious compared to all these other factors, and that's the only issue.
If it's egregious, Your Honor, in all likelihood, it's not going to just be discretionary aspects of sentence.
I don't see that at all,
That's not
counsel.
true. They're two different things.
You're coming up with an argument that surprises me. I don't follow your categorization of appeals in criminal cases. I still don't understand your response to the question, what prevents them from just barring all challenges to discretionary aspects of sentence, if you're right? Is there any answer to that question?
I don't think the statute stops them from it, and I don't think the Constitution would stop them from it, because the Constitution didn't address that question in the first place.
Counsel, that's where I'm really struggling with this argument, because I'm looking at the words of the Constitution. You're reading into this some historical perspective that has nothing to do with the language of the Constitution. The language of the Constitution couldn't be clearer. There shall be a right of appeal.
It says there should be a right of appeal. It doesn't say that we're going to constitutionalize every conceivable decision that a judge might have made.
Well, it's either a right or it's not a right.
It's not exactly. I mean, the background that you're reading into it, first of all, the legislative history or the constitutional history about this amendment is about 1.5 pages long. I mean, and nothing could be clearer. This was a huge expansion of the right of appeal from that which existed under the prior Constitution. Huge expansion. And the limitation that you're reading into it is just totally absent from the language of the Constitution. That's what I'm struggling with.
It was definitely an expansion of the right of appeal. And as Justice Papadakos pointed out, it was at the Constitutional Convention, they were saying, we didn't have, in lots of these cases, people didn't have a right of appeal. They couldn't appeal. So they were concerned about, they talked about what they were concerned about. It was errors of law and insufficient evidence. They weren't talking about discretionary aspects.
Yeah, but see, prior to the 68 Constitution, there was a very limited right to appeal, felonious homicide and other cases in which the legislature allowed a right of appeal. That's essentially what it said. I mean, what you're talking about is sort of reinserting what existed in the 1874 Constitution. I mean, this did exactly the opposite. It took out that discretion of the legislature to otherwise determine which cases could be appealed and just created a right of appeal. That's what I'm struggling with the argument.
I'm not saying that the legislature said you can't appeal a summary case. You can appeal it. You just can't appeal based on historical jurisprudence.
Where does that come from, though? There's no historical jurisprudence footnote to Article 5, Section 9. I mean, it's a fairly crisp recitation of what the rights are. That's why this historical perspective is just not anything that's embedded in the actual language of the Constitution. There's no ambiguity. I mean, we can't even look to find what you're talking about because there's no ambiguity in what the Constitution says. Let me ask you a question. Let's assume that, just for the sake of discussion, because I don't know if we have to reach the constitutionality of 9781, but if we did, would there really be that many more appeals to the Superior Court?
I can't answer that question. I can tell you that
because having come from the Superior Court, much time is spent on deciding whether or not there is a substantial question. I mean, I couldn't even guess at the percentage of the cases that involve that issue, but it's a significant percentage.
Well, if you accepted my argument that the constitutional provision was not a wide open invitation to appeal every single aspect of the sentence, then the legislature came along and said, okay, we're going to create a comprehensive sentencing scheme along with...
That wasn't my question. My question is, suppose we said 9781 is unconstitutional. You can't limit the right to appeal. How does that really impact the caseload of the Superior Court vis-a-vis these discretionary aspect of sentence cases?
I can't answer that. I can tell you that historically we think the legislatures are better equipped than courts to make those determinations. When they passed the sentencing guidelines, they published the proposed guidelines. They solicited input from all the stakeholders and experts, people in the criminal justice system. They had hearings, debates. That's what legislatures do. courts are not in a position to perform comprehensive investigations like that and make decisions about comprehensive schemes. That's something that we generally leave to the legislature. They took that project on, they created the sentencing guidelines, but at the same time, they said, we're creating this jurisdiction to review what previously was not, in their view, reviewable, which was just pure reweighing of a judge's, you know, which factors he gave more weight to, which factors he gave less weight to. They said, for that kind of appeal, we're going to limit this to felonies and misdemeanors. And it's quite, I think I agree with the Superior Court that the language of that statute is plain and unambiguous. It's backed up by many, many sections of the statute. They all invoke, they all contain that limitation. They contained it from the very beginning. There's no doubt that the statute does not, I think, that the statute does not apply to summary cases. That doesn't answer your question about what happens if we eliminate 9781. I think what the legislature would say, if you want to apply the framework that we have for 9781 to summary cases, then propose that to us and we'll hold hearings and do the same thing for that we did before for felonies and misdemeanors. But that all presupposes that you disagree with me, that you think the constitutional provision is clear on its face, that it doesn't...
In your view, what is it about this constitutional provision that is not clear and unambiguous? What is it about this language that you find to be ambiguous?
Only that if you have to look at the constitutional provision against the backdrop.
No, you don't. No, you don't look at the backdrop. You look at the language of the Constitution, and if there's no ambiguity, you stop.
Okay,
I mean,
so
that's what I'm struggling with about your argument.
if you're saying that the intent of the drafters is not meaningful, that all you look at is the language
of
itself.
the Constitution. The best indicia of the intention of the drafters is the language of the Constitution itself.
Okay. And if the Constitution said there shall be a right of appeal and it shall include every issue in the case, including those hitherto deemed not appropriate for appellate review, like...
There's no language, there's no limitation language in the Constitution.
Okay, there's no limitation
There shall be a right of appeal.
So it doesn't address it expressly. I can't deny that it doesn't expressly, I mean, it's stated in very general terms. That doesn't mean that, the legislature and the courts can't make decisions about what kinds of appellate issues are necessary in order to effectuate the right they create.
If you're correct, this should have said, unless otherwise provided by the General Assembly, there shall be a right of appeal. But see, it doesn't say that. And your entire argument is based upon that proviso.
My argument is based on the intent of the drafters, yes. And I don't think you can read into the intent of the drafters that although there had never been appeals that were just based on reweighing permissible sentencing factors, they suddenly intended to create that without saying so. I think they would have said so if they intended that result, and they didn't.
I think we get it. Are there any other questions? Thank you both very much. We call the next case, Mr. Minner.
Wegmans Food Markets versus Bonnie Cole, representing Wegmans, Mr. Arthur Jr., representing Ms. Cole, Mr. Charles Wayne.
So excited.
Good afternoon.
Good afternoon.
In this case, this involves an employer's petition to suspend a claimant's workers' compensation benefits based upon her failure to stop smoking after she suffered a work-related incident resulting in fractures to her lower right leg. Specifically, physicians had advised the claimant to stop smoking during her recovery period and had also prescribed an antidepressant medication to help curb her smoking habits, which the claimant used for a period but then stopped taking and continued smoking. Section 306 of the Workers' Comp Act addresses a claimant's forfeiture of medical benefits and states, if the employee shall refuse reasonable services of healthcare providers, surgical, medical, and hospital services, treatments, medicines, and supplies, he shall forfeit all rights to compensation for any injury or increase in his incapacity shown to have resulted from such refusal. The Commonwealth Court found that Section 306's forfeiture provision requires the employer to initially prove that the employee refused reasonable medical services or treatment. Finding that medical advice is not a medical service or treatment under the forfeiture provision, and that the employer presented no evidence that her prescribed smoking cessation treatment was reasonable, the court held that the employer's suspension petition should have been denied. In this appeal, we consider whether Section 306's references to medical services and services rendered by physicians or other healthcare providers includes reasonable medical advice. We also granted review to address whether for medical services provided to an injured claimant to be deemed reasonable under the forfeiture provision, such services must result in physical improvement of the injury or an increased likelihood of a return to gainful employment. If there's anything else for you to say, please proceed.
Madam Chief Justice, I think you've done my argument. May it please the Court, Madam Chief Justice, Justices, my name is Burke McLemore, and I'm privileged to represent Wegmans Food Markets Incorporated, and this is my final appellate argument. I'd like to sort of clear up the elephant in the room on this case. The elephant in the room in this case is the interpretation of the statute that always says you should always look toward interpreting the statute in favor of a claimant, all right? In this particular case, though, we have a situation in which the claimant herself was the one who was responsible for her own injury. And this court in the Muse case put it quite bluntly. Who can be cured and won't soon dries sympathy and wearies the most willing helpers. Now I'd like you to imagine, if you could please, the following situation. An individual becomes injured at work and sustains an ankle fracture, exactly like happened here. And she goes for follow-up with her doctor, and the doctor said, Mrs. Cole, you have to keep that wound clean and dry. If you don't keep it clean and dry, you're going to develop an infection. And when you develop an infection, it's going to lead to osteomyelitis, and then you're going to lose the leg. And this admonishment is given repeatedly by every physician the person sees, irrespective of whether she receives medication or anything like that. The rule is keep the wound dry and clean. And when she doesn't do so, guess what? She develops osteomyelitis and loses the limb, knowing full well exactly what the harm was anticipated to be.
So, counsel,
Is that advice? Is that medical advice, or is that part of the treatment plan? And is there a difference?
That's my whole point. It's the Commonwealth Court missed the boat, in my opinion, by failing to differentiate between active medical care and passive medical care. This is what I would call passive medical care. In Mrs. Cole's case, the passive medical care was the admonition, Mrs. Cole, you have to stop smoking.
But counsel, I'm struggling with your interpretation. It seems, you're saying advice is the medical service, but there's medical services being furnished in the course of which advice is given. So let me give you a different hypo. Suppose you go to a domestic relations lawyer because your fiance presented you a prenup, and that you consult with that lawyer, and that lawyer urges you not to sign it, but you disregard his or her advice, and you sign it anyway. You did not follow the advice, but you got legal services, didn't you?
Well, that's true. You did get legal services.
So how are you conflating for this woman the advice and the service?
Right. I will point out that the workers' compensation statute says the carrier or the employer has to pay for all medical treatment, irrespective. And in the circumstance that I mentioned earlier with the keep clean and dry, you go into the doctor's office, the only thing he does is he looks at your leg and says, keep it clean and dry. Do you think for 1 second that the comp carrier or the employer wouldn't have to pay for that visit? It's a two-way street. If you have to pay for the visit, I'm sorry.
No, please proceed.
If you have to pay for the visit, that's the treatment. You got the treatment and you disregarded it.
But doesn't it depend in some ways on the nature of the treatment? That seems much clearer to me, not speaking for my colleagues, but the directive that in order for your wounds to heal, you need to keep it clean and dry seems much more akin to medical treatment. I mean, it is advice, but much more akin to medical treatment than you should stop smoking, or you should lose weight, or, lifestyle advice in that way.
There's an interesting little factor that goes into this as well. And you pointed it out, Chief Justice Todd, during your introduction of the case, and that is she received not only counseling, she got medication, and she didn't use it. And that was specifically found by the judge that she didn't use it. And what's really important here,
Counsel, can I stop you there? Say she broke her leg or broke her ankle along the lines of what Justice Weck and the Chief was just asking you, and the doctor said, you know what, you're grossly overweight, you're obese. I'm going to prescribe for you a GLP-1 or a semaglutide. I think you need to lose weight because it's going to help your leg clear. And she decides she doesn't want to do that. How do you force somebody to go on some kind of Smoking is illegal. It's legal.
And it's an addiction.
It's an addiction. It's legal. It's no different than, you should eat more vegetables, or you need to lose weight, or you need to stop drinking alcohol, because all of these things would basically help your body to recover itself. But if they can't do it, how do you distinguish between lifestyle advice and medical advice, medical treatment?
And that's a point that I was going to get to, and I'm glad you raised it. In this particular case, there was no claim by the claimant that she couldn't stop smoking. She never raised it. She never said, I can't stop, or I'm having a problem stopping, or anything like that. And that was specifically found by the judge.
What does the smoking have to do with a fractured ankle?
The smoking has everything to do with the failure to heal. And it was the unanimous medical opinion of all the doctors who testified.
So you're saying Wellbutrin resolves fractures?
No, Wellbutrin was designed to help her stop smoking.
I know why Wellbutrin, but
And Wellbutrin, and honestly, Mr. Justice, Wellbutrin isn't the issue here, in my opinion. In my opinion, the issue is, what was the medical advice?
But
medical
counsel,
advice.
she didn't refuse the medical services. If your argument's correct and you prevail, it would seem to have some significant consequences statewide, because anybody who goes to see a doctor gets all sorts of advice, lose some weight, get some exercise, and if you're right, by logical extension, I don't see the principal difference with denials of coverage for all manner of lifestyle choices people make. Oh, you ate a piece of cake, you refused medical services because your doctor said
Don't eat cake.
lose weight, or you didn't go to the gym, so you didn't follow his or her advice. We deny your claim. So it seems like a slippery slope when you say a patient who never refused medical services but perhaps didn't follow advice on one aspect of her behavior should be denied coverage.
Well, Justice Wecht, one of the cases that this court dealt with before, I believe it was in the Muse case, dealt with physical therapy. And exactly what you're talking about happened. The claimant was told to go to physical therapy, and he was a poor no-show. And his benefits, it was the Joyce case, his benefits were ended. And that was an amputation case as well.
Well, that's why I ask, maybe it's not a matter of, is it medical advice in this box, or is it medical treatment in this box, but rather it depends on the nature of the medical advice. If you're told you've had surgery, and in order for you to heal from that knee replacement or whatever, you must go to physical therapy for it to work, that seems like it goes beyond medical advice and is part of the treatment plan. So I wonder, is there some room here for it depends?
Well, and that's exactly it. Every case is fact-specific, and this one in particular is unusual and fact-specific. I can tell you that it's always remarkable to me. I've been practicing almost 50 years now, and almost exclusively in workers' compensation. And this forfeiture provision of the Act goes back to the beginning of the Act in 1915. So it's always been there. But what has also been there is the requirement that the employer pay for almost every kind of treatment under the sun, short of voodoo and exorcisms. And the Statutory Construction Act defines medical care very broadly. And
yeah, I don't think there's. I think that's a compelling argument, Mr. McLemore. I though, to the Chief's point, I think these are incredibly fact specific. You have some really good expert testimony on your side here about the ramifications of smoking and healing, and particularly the complications that developed with this woman. But kind of the Chief's point, though, is your hypothetical is a much clearer case than this one. Your hypothetical is the advice that was given was something that arose out of the injury. And here the advice that is being given is not arising out of the injury, but arising out of who the claimant is. So, for example, an employer hires I don't know what the right term is. I don't want to use a wrong term, but an overweight person. That overweight person gets injured. The overweight person is going to have a harder time recovering from a particular injury than an underweight person. Why should the medical advice for purposes of refusal be tied to changing who the person was? Because your point, I completely embrace this idea that if this person has surgery and my advice and treatment is you have to keep this clean, I could see that as perhaps a forfeitable problem if they don't keep it clean. But the advice here was not post-injury advice. It was trying to alter who the claimant was.
I recognize your point, but again, it's fact-specific. And here, not only was she given the advice, she understood fully the ramifications of failure to follow that.
But you agree, though, the advice really wasn't keep the wound clean or go to physical therapy. The advice was, I want you to be somebody that you're not. I want to change. I want to take what you were before the injury, and I want to make you into somebody different because it's going to help you heal better.
Okay. Well, let's assume that that's the fact. How does that change the ramifications of what she did here? She knew what was required.
Well, I guess it's a question of did she refuse it?
Okay.
Can one really refuse to change who they are?
She never made any claim or contention that she was unable to...
No, but you have to prove she refused it. She may have failed. She may have failed. Well, but did she refuse to alter who she was at the time the employer hired her and at the time of her injury?
Let me ponder that for a second.
Okay.
I agree you take the employee as you find them. But when circumstances occur that change the life of that person, you have to adapt. So in the example of the individual who was directed to go to physical therapy, okay, he could choose go to physical therapy or don't go to physical therapy. He may be overweight, and the doctor may have said, go to that physical therapy because you need to lose weight.
Yeah, but it's a false analogy. It's an incorrect. It's not on all fours. Let me put it that way, because here she availed herself of the services and apparently didn't take the expert advice. Failing to follow advice is not refusing medical services. In the case you're talking about, apparently services were refused. And that's a different case, I think, than what we're talking about here. I think I think you're arguing necessarily for a new development of the law rather than a validation of what the law is now.
Justice Weck, I'm trying to figure out what the difference is between refusing or failing to keep a wound clean and dry, which I think we can all agree would be reasonable medical advice. That's failure on her part. It's a refusal. When she doesn't do it, she's refused it. When she doesn't quit smoking, she has refused it.
Let's follow through, or let's tease that out. So there's an open wound. The doctor prescribes a service and gives you a particular antibiotics, cream, ointment, and the person refuses to put it on their skin. That's a service rendered for which she forfeited. She'd gone in, the medical service was to relate to the broken ankle. The advice was stop smoking. What service was completed in the comment, stop smoking, that would trigger a forfeiture of service?
The same trigger that triggered keep it clean and dry. It's the same thing. It's the doctor telling her what she needs to do to get better. That's the service. That's the medical service. Not just telling her, but telling her why and telling her how and working through it with her. That's the medical service. That's what was provided here, and that's what she didn't adhere to.
Tried was the prescription for the ointment to place it on, and that part of the policy is to keep it clean and dry. That's my fact scenario. There was a service. Are you indicating that service equates to advice?
Yes. I mean, that, in a nutshell, that's it. That's my contention. That if you don't follow the advice, and that's the nugget here. If you don't follow the advice and you get worse, that's on you.
Let's hypothetically go in and the doctor says, oh, it looks like you have a deviated septum. Your insurance doesn't cover it, but go get a nose job. I'm going to tell you need a nose job.
Different scenario.
Why?
Different
It's
scenario.
a service. I'm telling you, you need a nose job to get your deviated septum corrected, but I don't have the insurance to pay for it, and you told me my deviated septum isn't that severe.
Well, that's taking it beyond. They're telling you to go get the service elsewhere.
If we follow your recommendation, that can happen, and that would be an absurd service.
And in that circumstance, Justice Doherty, Doherty, forgive me, I should know that. I grew up in an Irish town. In that circumstance, the advice given at that appointment is going to have to be paid for by the insurance company, right? Aren't they going to have to pay? Yes.
Not if it's not reasonable and necessary advice. Not if it's completely unconnected to the injury for which the claimant was being treated.
True. I mean, if she came in with a broken ankle and he treated her for the sniffles, different story.
Your answer to Justice Doherty's question is it still has to be reasonable and necessary advice.
Still has to be reasonable and necessary. There's
one more hypothetical. If, in this case, instead of offering her an antidepressant to assist with her cessation of smoking, what if the doctor had said, I'm going to send you to this program, this counseling program, or hypnotist or whomever to help you quit smoking? Would that change the analysis at all?
No, it doesn't change the analysis. It's just a different modality. This court has already, I believe, ruled on the issue of whether you could require a claimant to go, for example, for inpatient treatment for mental health issues.
Mm-hmm.
So, there's a whole, and that's the whole point of my argument.
So you want the blanket rule.
But counsel, there is no modality of treatment involved in your hypothetical.
And that's exactly
none whatsoever.
That's exactly my point.
Quit smoking.
There is no specific modality required by the Act. It is the giving of the advice itself with a known consequence if you don't
Equals
follow it.
treatment.
But if any of us go to our PCP for our annual physical, we're going to get the services. We're getting the services. We've had the medical exam and whatever. And in the course of that appointment, the physician might give us all manner of advice. And by the way, different physicians might very well disagree about aspects of that advice in any given case. And you're saying that every one of us, hypothetically, would be refusing medical services if there's any aspect of the advice that any of us got in the course of our physicals.
Well, that's true. There's no question about it. It's a question of choice. You have that choice. The Act gives you that choice. It says follow it or don't follow it.
But smoking is an addiction.
Beg your
Smoking is an addiction. By definition, it's not a matter of choice.
Okay.
You agree with that, correct?
I'm deaf in this year.
I'm sorry. Smoking is an addiction.
Yes,
You agree with that?
I do.
So it's not a matter of choice. It's not a matter of choice for this claimant. She would have liked to have quit smoking, but she's addicted.
That's not.
Isn't there a requirement that the assistance has to be offered to help her do that, and what's recommended is likely to succeed? Like take Wellbutrin, for example. How successful is Wellbutrin? Do you know? It's not in this record, but how successful is it? How successful is the Wellbutrin? But see, isn't that the key? So if the issue is she refused to take this medication that somebody offered to her, but we don't know whether it would have worked or not. We have no idea.
Well, we do
I think that's the Commonwealth Court's point.
We do have a good idea.
What is the likelihood of it being successful?
We do have a good idea whether it would have been successful or not, because she said at times she quit, and then she would start up again.
But that's the nature of addictions.
That wasn't the evidence. That wasn't the evidence, and that wasn't in the findings of fact.
truly-
Findings of fact were that she was offered the advice and knew what it was, and knew what the consequences were.
It's an interesting question, and we truly do understand.
Can I just mention the second point real quick?
Absolutely.
The second part of my argument.
Absolutely.
The second part of my argument deals with the issue of whether the treatment or medical services, or whatever you want to call it, would have made the person more employable. That is a fallacious argument entirely. And it's fallacious because the statute itself says that you have to pay for all medical treatment, period, irrespective of impairment. So there are really two parts to the workers' comp equation. There's the wage loss part, and there's the medical part. Even if the treatment had not made her more employable, and incidentally, in this case, the judge specifically found that she would have been more functional. He specifically found that as a fact. When you increase the injury or cause it to get worse, you thereby require the carrier and the employer to incur additional expenses for medical care. So the Commonwealth Court, I think, just got it dead wrong when they said that the medical care must make the person more employable. Employability simply is not the issue in the case. And in fact, if employability was the case, the Tobias case decided by Commonwealth Court a number of years ago showed just how disconnected medical care is from the injury. In that case, there was a gentleman who was a paraplegic, and the court ordered that the carrier pay for artificial insemination of his wife under the medical provisions of the Act. One final point I would make, and that is this. Commonwealth Court made a big deal about how medical advice was not specifically enumerated in the statute. There are a lot of things that aren't specifically enumerated in the statute. We could talk about acupuncture or physical therapy, or more recently, in the Schmidt versus Schmidt-Karafides case that this court decided within the last year, CBD oil, ointment. That's not in there. It's not specifically mentioned, but it's covered by the Act. So thank you very much.
Thank you very much. Let's hear from Mr. You'll have to pronounce your name for me. Wengi? Wengi. Yes. Let's hear from Mr. Wengi.
Thank you. Good afternoon. May it please the court. Kelvin Wengi, I represent the interests of the injured worker in this matter, Bonnie Cole. I do want to start by talking about the language of 306F.18, which is obviously the focus of this issue. I want to talk first about the plain language of that portion of the Act, and then I want to talk about possible interpretations where Mr. McLemore just left off. When we're looking at interpretation or discussing interpretations of the Workers' Comp Act, we have to do that within the context of the major tenets of the Act, which is that the Act is remedial in nature and that the language of the Act must be interpreted in favor of the injured worker.
In the case of an ambiguity.
Yes.
Right.
In any event. That's the language of this court.
I don't know about in any event. I think we apply the plain language of the statute, and if it's ambiguous, then we interpret it in favor of the plaintiff.
Sure. Agreed. In this case, the issue being what is the statutory definition of medical treatment. The legislature did not leave that ambiguous. They actually defined what medical treatment is. It is a surgery, a service, medicine, or supplies. Medical advice is not delineated. It's not contemplated by the legislature, and it's not.
The insurance company has to pay for the hospital, pay for the doctor's visit, right?
Yes.
Okay. So, but they're not paying for the advice at the doctor's visit?
No. Well, that doctor is going to physically examine you.
How do you know that? A doctor may not physically examine. They may just sit with the claimant and talk to the claimant and give the claimant advice. But the insurance company or the employer would still have to pay for it.
Do they? I don't.
I would venture. It's an interesting rhetorical question. I would venture to guess if that doctor's appointment was not paid for, you would be arguing in favor of being paid for.
Well, what are they billing for then?
They're billing for their time.
Service, yeah.
Well,
that's what doctors. That's what they do. They
So
bill.
then-
They don't. If a doctor walks into the office and you have an appointment and the doctor doesn't examine you and all the doctor does is say, I looked at your charts. This is what I think you should do to make yourself healthier, and then leaves the room. You think they're not going to bill your health care?
Well, then they will, but what are they billing for? So here is the commonality among all of the delineated definitions of a medical service in the Act. The surgery, the medicines, the supplies, they all involve medical expertise and medical resources in order to accomplish that. But probably more importantly to your question, they all involve a billing code. Where is the billing code for medical advice? It doesn't exist.
The billing code is actually for the appointment.
Right, but not for medical advice.
Well, but the appointment.
So the
appointment includes medical advice. I mean, I don't think you need to win this idea that I don't think you need to win your case. I don't think you have to prove this, but I have a hard time believing that a doctor doesn't bill for medical advice, and that the insurers and employers don't have to pay for medical advice. What you seem to be saying is the doctor, when they bill for their appointment and they put the code in, and the code, by the way, is the injury. They're not lawyers accounting for every 6 minutes of their time. For this 6 minutes, I gave advice. For this 6 minutes, I did a physical examination. They're paying for the time with the physician. That's what they're paying for. I don't know how you're getting the idea that they're paying for something else, or maybe they're not paying for it at all. They really are looking to see, well, we're only going to compensate the doctors for the time they wrote the prescription on the piece of paper, or the time they checked for their pulse. That's not how it works.
So to answer your question, I want to piggyback on what Chief Justice Todd had said, and I think what you were describing was there's a difference between giving advice for lifestyle choices and personal choices, as opposed to giving advice of medical treatment, which is an extension, or advice which is an extension of medical treatment that doctor is providing. So if you go to the doctor and they advise you, well, I think you need shoulder surgery if you're going to fix your rotator cuff repair, yes, I agree, then that advice is encompassed within that doctor's visit.
So
if at the end of the...
Can I just follow up on that? Just like, so by example, instead of saying, if the case was not, Ms. Cole, I think you should stop drinking and smoking, versus Ms. Cole, here's my prescription, you're going to the Acme, treatment providing facility for smoking and alcohol, addiction. You would concede there a refusal would lead to a suspension, would warrant a suspension, right?
I would agree that would be a lot closer to a medical service which requires some medical expertise, some medical resources in order to accomplish, and you're actually offering a treatment to that individual, not just good old-fashioned advice. So,
Mr. McLemore would say here the doctor did offer a treatment with the advice. He offered the Wellbutrin, which he prescribed, saying that it will help with your need for smoking. Whether or not that was true, I don't know, but the doctor did go beyond just the advice.
correct, and she didn't refuse. She tried the Wellbutrin in good faith. It actually curbed or decreased the frequency of her habit. Ultimately was not able to completely stop her habit. But I think in order to prove that treatment is, if you're getting to that next step, is that treatment versus the next step is that treatment reasonable, you've got to show that it has a high probability of success of resolving the medical issue. In this case, we know, because we have the benefit of hindsight, it did not resolve her issue.
Where's the high probability come from?
Where'd that come from?
What's that?
Where's the high probability test come from?
That's essentially the definition that's used to determine whether or not the treatment recommended is reasonable.
In what context? In the IRE context, or not IRE context, in the reasonableness necessity context, high probability isn't part of the test. The question is, was the medical treatment reasonable in the sense of medically reasonable to treat the injury and necessary, and nothing about probabilities. Is that like a Commonwealth Court opinion, or?
Counsel, you're talking about Muse, correct?
Talking about what?
You're talking about the case Muse?
Correct, yes, correct. What this entire case is based upon, the Muse petition.
Well, you're
that's the
saying you
test
don't need
for
a
Muse.
reset issue, right? You're saying if we, my understanding is if we affirm, we don't need to reach that second issue. Isn't that right?
That's exactly what I'm saying. I'm saying I'm not even.
This high probability, just following up on Justice Brobson's point, you could envision. You could envision services where you might find it very reasonable, even though you don't have a high probability of success, right?
I mean, what if it's the only probability? Right. What if the treatment is if the only known treatment for the work injury is an incredibly, is a drug that has a lot of side effects, but it's an entirely reasonable prescription to make under the circumstances and is necessary for the person to have any chance of recovery. That's not enough, in your view.
It could be, but in this case, she didn't refuse it.
No,
and
I
it didn't ultimately work.
I'm just going to this high probability problem, which is the second question I think we took.
Sure. I guess my point, and I think Justice Weck kind of pointed this out, is we could get to that second kind of prong, and I think that kind of gets eliminated by the fact that she did try it in good faith and didn't quote unquote refuse it. But I guess my point is, you don't even get to that question if you determine that advice is not medical treatment or medical services provided.
Well, what about, go ahead.
Counselor, I asked your opposing counsel what his answer is to issue number one, which is, in essence, the issue we granted is, are medical services and, quote, services rendered by physician or other healthcare providers, does that include reasonable medical advice? His response was yes. What is your answer, considering I view medical advice as a personal recommendation and a medical service as some actionable service like taking x-ray or blood? I don't view them the same. What is your answer? And depending upon that answer, you indicated that this case is based upon a Muse petition. And a Muse petition is a refusal of services. So the compound question would be, by offering and administering the Wellbutrin, which she took but she discontinued, does that discontinue equal refusal?
So My doctor, yes, I understand your question. My doctor tells me I should get more sleep, drink less coffee, and work less, because I'll be a healthier person.
You look pretty healthy.
Appreciate that. That is not a medical service rendered. And the fact that I got up this morning at 4:30 to get prepared and drive out here and drank 22 ounces of delicious dark roast Wawa coffee on the way, and I'll probably work tonight, doesn't mean that I am refusing...
Because you can't sleep.
That's right. It doesn't mean that I'm refusing medical treatment. It just means that I'm a human being, and I have a life and responsibilities and an addiction to my morning caffeine.
That is a point that there's a lot of ways to skin the cat in this case, right? Not all of them require us to decide whether medical advice is a medical service. There's also the question of whether she refused, and whether that refusal meets the statutory requirement of causing or exacerbating the result here, which nobody even talks about, although I think the expert reports and the WCJ's finding might be in their favor on that.
I think there's another word that I think we were perhaps was said or was close to being said during Mr. McLemore's presentation, close to refusal, but it's fault. The problem with this is we are introducing, with this argument, we are introducing fault into a no-fault system. Our Workers' Comp Act is a no-fault system. Injured workers in this state gave up their constitutional right to sue their employer for tort over 100 years ago. And so what the employers got was protection from damages, limitation on damages. So it was a big concession. And what the workers of Pennsylvania got in response was a no-fault system. So negligence is not a part of our system, whether it's by the defendant or the employer, and there's no comparative negligence on behalf of the claimant either. And so what we're proposing here is that we're introducing fault into this system and blaming Ms. Cole because she has been smoking since she was 12 years old, before she ever started working at Wegmans, before her leg was crushed by a forklift by no fault of her own, and before her leg was taken from her below the knee. We're blaming her for being addicted to cigarettes.
Okay, could we go back to the fundamental question of, is medical advice the same as medical treatment or medical service? And I suggested to your opposing counsel, Mr. McLemore, that it may be an it depends answer. Sometimes maybe the advice you should lose weight is just advice. Maybe the advice, you just had your shoulder replaced, you better go to physical therapy or you're going to be stiff for the rest of your life. Maybe that is more akin to a medical treatment than advice. So, you know, in my view of this, and my question to you, can't we look at it as a spectrum rather than this or that?
Yeah, I think that's why I was suggesting that if you go get a surgery and at your next follow-up with the doctor, he or she says you need to go get physical therapy or you might develop a frozen shoulder. That advice is a recommendation that's an extension of the medical treatment or the surgery that was already provided. It's directly related. There is a direct connection.
Type of advice.
Correct. Any other advice like, well, you should also lose weight and eat your vegetables and drink 80 ounces of water a night and stop smoking, those are tenuously perhaps related. I don't know. I'm not a doctor, but I think I think if once you open that door, you're inviting a lot of infringement onto someone's personal lifestyles, and then again, where does it stop?
Well, where you're closing the door, you're saying the medical advice to get physical therapy is not different than the medical advice to quit smoking or stop eating so much?
I believe it's absolutely different. Absolutely different. Yes.
One is triggered by the injury, the other is trying to alter who the claimant is.
I agree 100%.
All right, any other questions for Mr. Wenge? Thank you both. And Mr. McLemore, are you telling the court that this is your final Supreme Court argument?
My final any argument.
It's your swan song.
Congratulations.
Nice
Well-
job on your last argument.
Does that mean you are retiring?
Pretty close. My wife gave up her license in July, and I'm working out my last few cases, most of which are with Mr. Vingy's firm.
No, counsel, you could become an emeritus lawyer. You could become an emeritus lawyer and still serve the
Pro bono.
pro bono,
Yes.
do pro bono work. You're good at what you do.
My license,
Yes.
I intend to practice.
Right. Well, congratulations.
Yeah, exactly.
Congratulations
Exactly.
to you.
Congratulations.
Well earned retirement.
Thank you.
Thank you both.
See you guys.
Would you adjourn the court, Mr. Minnick?
We have one more case.
One more case.
Oh,
We're going to skip the last case.
no, I
Okey-doke.
did that once before. My mind's getting ahead of the cases. I'm so sorry. Would you call the last case?
Here in Whittington versus Joe Daniels, representing Whittington.
I'm done.
Representing Mr. Daniels, who's got 3 minutes.
I got involved wishing Mr. McLemore a happy retirement. I neglected our last case. In this case, appellants entered into a contract for the construction of a home and gave the contractor a $10,000 deposit. That was in April of 2015. They later terminated the contract, but learned in October 2015 that the contractor would not refund their deposit. In April 2017, appellants filed a pro se complaint in the Magisterial District Court, which ruled in their favor. Pursuant to Magisterial District Court Rule 1004B, the contractor appealed the award to the Court of Common Pleas and requested the prothonotary enter a rule requiring appellants to file a complaint with the Common Pleas Court within 20 days on pain of judgment of non-pros. Appellants failed to timely file the complaint, but the contractor neglected to file a precipice seeking the entry of judgment non-pros. Over 3 years later, the trial court gave notice that it intended to terminate the case due to inactivity. Shortly thereafter, appellants filed a complaint in the Court of Common Pleas alleging inter alia a claim of conversion against the contractor, and the contractor raised a statute of limitations defense. After the jury found in favor of appellants, the trial court granted the contractor's motion for a directed verdict based on the statute of limitations. The court noted that appellants did not file their complaint within the applicable 2-year statute of limitations and found that the contractor's failure to file a precipice for entry of judgment non-pros did not preclude a statute of limitations defense. The Superior Court affirmed, we granted review to consider the propriety of the lower court's decisions. Please proceed.
Madam Chief Justice, and may it please the court and other justices, my name is Jason Pyatt. It is my honor to rise today on behalf of Gary and Donna Whittington, who are behind me. This case really presents a fundamental question about the integrity of Pennsylvania's unified judicial system. Can a claim that was timely filed at the MDJ, fully litigated, twice tried on the merits, and twice decided in the Whittington's favor, nevertheless be extinguished by a procedural forfeiture rule that appears nowhere in this court's rules? There's no question, and I think it's undisputed, that the action was timely commenced in the Magisterial District Court. The appeal was perfected by the defendant upon service of the notice of appeal with rule to file complaint pursuant to 1004B. And that's an important distinction here. 1004B perfects the appeal upon the service of the rule, not upon the service of a complaint by the opposing party. As has always been the case in Pennsylvania, the burden of perfecting an appeal falls on the appellant. And in this case, it was the defendant. Once it was perfected, the rules provide remedy for a defendant if the plaintiff doesn't proceed appropriately or promptly. The rule is clear. It is made out. It's 2 rules: 1004, which then leads us to Rule of Civil Procedure 1037. 1004B is clear. The remedy is, quote, or suffer non-pros. Non-pros requires a precipice. A one-page document, as your honors know, it was not filed here. Absolutely. The claim was dead.
Okay.
We would not be here. We would have not been in Superior Court.
Filing of the original complaint tolls the statute of limitations forever until the defendant does something, takes some action.
Until the rules extinguish the claim. And the rules would extinguish the claim by either non-pros, dismissal under 230.2 for inactivity. As Chief Justice Todd mentioned, that notice had been sent out, or by verdict. And in this case, we went to verdict. But the point is that under 1004B, which is very distinct from A, under this rule, that statute should have been told until the rules extinguished it, not a secret clock that began to run that had never been announced before. And I think that's really an important distinction, because in the note to 1004B, it makes clear that this will be handled by Rule of Civil Procedure 1037A.
So it's your position that because no precipice was filed pursuant to 1037A, you had the right to file that new complaint over the 2-year statute of limitation, and in your case, the 3rd year?
Yes, Your Honor.
And that's how it is?
Yes, Your Honor, because there's kind of an important, and I'll jump ahead a little bit in my argument, but the point is, this isn't a new cause of action.
Right.
So this isn't a new case, so to speak. It doesn't fall under commencement of the action. The commencement of the action, as 5503, the statute specifies, filing in the magisterial district court commences the action.
Even though there's a trial de novo, even if there's a trial de novo in the common pleas court?
Yes, Your Honor, and that's a very important point. The trial de novo is not a new commencement of the action. I liken the two as I compare them. The trial de novo here from MDJ to Court of Common Pleas compared to cause of action filed in Court of Common Pleas that's removed to federal court.
The action is continuous, it just is a new trial.
Exactly. And in fact, the Rules 1007 of the Rules of Civil Procedure for MDJs makes clear that those things are preserved. If defendant didn't want to see that happen, defendant need have only filed the precipice and killed the action, or, and the other thing that didn't happen here, when we received notice and when I was retained, my clients received notice that this is going to be listed as inactive and the case dismissed. Defendant didn't oppose that.
How do you respond to the argument that your opposing counsel, that you didn't raise the conversion claim?
I would say two things, Your Honor. First, my plain reading, and I'm pointing to the reproduced record 57A, which is the MDJ complaint, again, construing it as written pleading, it talks about withholding funds and the inference in the way the writing is, despite having not executed the contract, so to speak. When he says he wrongfully withheld the funds, wrongful withholding, I would respectfully suggest, if I would have pled it exactly the same way in the Court of Common Pleas, my friend would have filed preliminary objections under 1028.
On the statute of and raising the statute of limitations to the defense, right?
No, Your Honor. He would not have that opportunity. Statute of limitations would be on the issue. Statute of limitations can only be raised in a new matter and only handled as a judgment on the pleadings, which again was not done here. But what my point is,
I think the answer to Justice Doherty, I'm sorry, is it Doherty? Justice Doherty's question is, you're not suggesting that a cause of action, say hypothetically you file a cause of action with the 2-year statute of limitations with an MDJ, the same fact pattern happens. Finally, you get hit with a precipice or you file your complaint. You're not suggesting that you can file a complaint after a statute of limitations that has already run on another cause of action outside the statute, are you?
not outside of the statute for what was told by the filing at the MDJ. So there's two pieces to that. One, we would argue that a plain reading of 57A, the reproduced record, which is the MDJ complaint, does sound in conversion.
Let me ask you this question. The MDJ action was actually a breach of contract, right?
I'm sorry, I'm having trouble.
The MDJ action was a breach of contract, right?
I would not say that, Your Honor. It mentions a contract, but it speaks to contract. It also speaks to wrongful retention of money. And the wrongful retention of money...
Let me just back it up without kind of labeling it. Breach of contract's 4-year statute of limitations, correct?
Yes.
What's conversion?
2.
All right. So if you file a cause of action with the MDJ under your fact pattern within the 4-year statute of limitations, and nothing ever happens until you get the notice of intent to terminate, but you're already past the 2-year statute of conversion, you're not suggesting he'd be precluded from raising as an affirmative defense the statute of limitation on the conversion, are you?
If the filing at the MDJ was done more than 2 years from the wrongful retention of funds.
Correct.
Filing at the MDJ, I agree that the statute of limitations defense stands.
Correct.
The question of if he files at the MDJ within those 2 years and then goes to trial still sounding in conversion, then my recommendation or my argument is that under 1004B, the appeal was perfected, the statute was taken care of, and the rules of this court provide the remedy. The remedy at that point is no longer a statute of limitations defense. You can raise it. We would ask for judgment on the pleadings on the plaintiff's side because once we were at the Court of Common Pleas, because I would have pointed to the date filing at the magistrate and the date of the alleged offense, which the accrual date was found by the jury. It was less than 2 years, so the statute of limitations is fine. The problem for defendant in this case is because they allowed the claim to languish, they would then say, well, you waited too long. Well, we at that point didn't have the burden to kill the claim if we felt we needed to.
Yeah, but you're assuming that the original magisterial district justice complaint could be considered to be a claim for conversion as opposed to just for breach of contract.
Doesn't matter, Your Honor. I will say, in the facts of this case, I would respectfully argue that it does sound in conversion. But even if it doesn't, even if it flatly doesn't, rule of civil procedure under MDJ, so RPC MDJ 1007, says that it may not be limited. May not be limited. Now, the way around that and why that makes sense is because of the timing of MDJ from filing of a complaint to trial, weeks, maybe months, but not years. And then you got 20 days. So it makes sense that you don't limit what happened in an MDJ sense. And it also goes to the policy issue of the MDJ system itself, because it's intended for pro se litigants, or at least it's certainly the most pro se friendly avenue that we as our courts offer. And so then under 1004, A or B, it gives that person time, if they want to seek counsel or if they want to do it themselves, to write a proper complaint that sounds, in all of our proper terminology, to sound in the claims that are being raised. So the system works. The rules work. There's a harmony with the rules. The rules as they stand up until this case, there's a beautiful harmony between an entry of a pro se litigant into an MDJ's arena and the flow that then proceeds to the Court of Common Pleas. The hiccup in that is this insertion of this rule by the Superior Court here. And so if you reverse, you eliminate that hiccup in the harmony, because then it allows the system to function the way it was intended when the system was unified. Now, there's two things I'd like to touch on because I'm sure my friend will mention. One is the case Lamp. Superior Court relied heavily on that. It is entirely inapplicable here, and not only that, it actually supports our position. Lamp is a Beaver County case where, as you know or may know, the old practice and sometimes was you'd file a complaint or a writ at the Court of Common Pleas. You direct the prothonotary, don't send it over to the sheriff, I don't want it served. Stick it in a drawer. Keep re-upping the complaint or the writ, and then eventually you serve it. So they would be stale. But the key point is that the defendant had no knowledge of the case. Then they'd serve it, and they'd move forward. So Lamp and its progeny tell us that you can't do that. You can't sit on a complaint or a writ and stick it in a drawer. But those cases all have to do with notice and service. That's all they have to do. In this case, not only do we have notice and service, we have trial, we have affirmative actions taken by the defendant on appeal. There's no question this isn't just apples and oranges. This is apples and I don't know, watermelons. It's so far off. The other argument my friend is likely to make is that somehow we can't add this new cause of action because of the rules under amendment, under Rule 1033, or that, and it somehow this isn't appropriate. The Provenzano opinion or rule in this court made clear that 1033 does not apply here. 1033 would be if the complaint filed in the Court of Common Pleas was then challenged, and we needed to amend after the cause of action had expired.
What about, counsel, I was waiting for you to address Rule 1004B, because I wonder what your response is to the failure to file the complaint within 20 days after the appellant's precipice. The language says you quote, suffer entry of a judgment of non-pros, and unquote. So why should we not read that as requiring an automatic entry of the judgment?
Two reasons, Your Honor, if I may. First, no comma after the word rule. We would read that as really what appears on the rule to file complaint, which is file with the complaint within 20 days after service of the rule, or suffer entry of judgment of non-pros. Following with that, if Your Honor jumps down to, lost my note, and the note to 1004B directs that this shall be handled. Now, I realize the difference between the note and the body of the rule, but I think that was very intentional language to say, under that part of the rule, it now will follow the 1037.
You have to reference 1037A.
That's right. And when you do that, it requires a precipice by the defendant for non-pros. And so without the precipice, it doesn't happen automatically. And these things don't, and they shouldn't. They shouldn't. This court has made clear so many times that cases should be decided on the merits.
But I mean, you do acknowledge there's an arguable problem there, because if there's a conflict between text and commentary, the text prevails.
There is, but first of all, I don't believe there is a conflict. It doesn't. It says or. It doesn't say shall. So it's not a directive to the prothonotary. To enter a judgment, there must be a precipice filed for any judgment. And so, absent the precipice, the judgment doesn't occur, and it's not an automatic process. It doesn't happen as a matter of law or a function of law, and that's just not ever been the case, and I don't think it should be now.
All right, any other questions for Mr. Pyatt? Thank you, sir.
Thank you very much.
Thank you. Let's hear from Mr. Evans. The closing act, Mr. Evans.
Oh, no. May it please the court, counsel. I'm Jeff
Hold the mic
Evans.
closer to you.
Sorry. I'm Jeff Evans, and I represent the defendant, Joe Daniels, in this matter. And I'd just like to address initially this idea about the interplay of Rule 107B and Magisterial District Justice Rule 107B and the Rules of Civil Procedure 1037. There is nothing in the text either of those rules that make it mandatory upon the defendant to precipice for the entry of a judgment of non-pros. That is simply not there. The mandatory language in 1037 says, the prothonotary shall.
But it's upon precipice of the defendant. So
Right.
where's the precipice?
But they shall upon precipice. That doesn't say that I have to file, or that a defendant has to file that precipice.
What do you think it means?
I think it means if the defendant files that,
And what if the defendant doesn't?
then I don't.
How do you
then-
get a judgment?
Well, I think you can wait to see if the case gets dismissed for lack of inactivity. But I would point out that there's nothing in that rule that prevents a defendant from, if a complaint is filed, filing an answer with new matter that contains a defense based upon the statute of limitations.
But there was nothing that prevented you from doing that in this case either.
I'm sorry?
There was nothing in this case that prevented you from doing so either.
That's correct. There was nothing that prevented me from filing the precipice.
So what's your argument then? You brought that issue up.
Well, my argument is there's nothing in the rule that requires me to file that.
But you don't get the you don't get the non.
You don't get the judgment.
I don't get a judgment of non-pros based upon that precipice, no. But if the court believes that plaintiffs, it's been a axiomatic that this court has said numerous times that once a plaintiff sets this procedure, a lawsuit in motion, they are required to exercise reasonable diligence to move the matter forward to conclusion. They can't stall the legal machinery that they set in motion.
But wouldn't that equally apply to a defendant?
No, because we don't have a burden to move the case forward. The plaintiff does.
And so, which connects to your statute of limitations argument, right?
That's correct.
But what's the authority? What's the authority for saying that commencing an action before an MDJ is insufficient to satisfy the statute?
Well, I think the rules of civil procedure talk about how an action has to be commenced.
Well, how is filing a complaint before an MDJ not commencement of an action?
Well, two things. First of all, the MDJ court is very informal. The same type of rules that apply in the Court of Common Pleas don't apply to an MDJ action necessarily. And so complaints can be very simplistic, and causes of action aren't necessarily set out. I know that my colleague had mentioned the complaint that was filed in this matter. There's no mention of wrongful retention in that complaint.
Well, it's not required to be more than it was, right? They wrote, Mr. Daniels, I'm quoting, Mr. Daniels failed to return our deposit of $10,000 for upgrades on a house which he never built upon our termination of the contract. It's just a little blank for you to fill in. We've all been at MDJ court, so we're familiar with it too. But what's the basis for saying that that's not commencement of an action? Because if you're right, why do we even have MDJs at all? I mean, why would anybody ever file anything in an MDJ court if, while that's pending, the clock is ticking? So that if things don't get resolved in the MDJ court, they're going to be forced to file in common pleas, right? So they don't lose the statute, and therefore you're subverting the existence of the whole MDJ system, aren't you?
Well, I guess my answer to that would be that if I would echo the sentiment of the trial judge, President Judge Myers. I think if the MDJ system is set to handle minor claims in an efficient manner that limit costs, if you choose to proceed through that system, there is some risk. And one of those risks are, do you meet you told the statute of limitations with respect to claims that you would otherwise raise in a court of common.
How can that be? Because the law provides for a de novo appeal.
Well, the law, and I was going to get to that as part of this argument as well. The law does allow, or does require a de novo appeal. Interestingly, the comment in the rule says that the court should treat this, the Court of Common Pleas would treat it as if it hadn't been filed at the district justice at all. That's the official note under, I think, Rule 104, I believe, where it talks about the appeal. Or I'm sorry, that's the official note under MDJ Rule 1007.
But counsel, the purpose of having a statute of limitations is to be certain that the defendant is on notice that there is a claim against him or her. You had notice that there was, your client had notice that there was a claim, and they knew the nature of the claim. That's the entire purpose of the statute of limitations. So once the action is filed before the MDJ, that notice requirement is fulfilled. You must be talking about something other than a statute of limitations, because that's the only purpose of a statute of limitations.
Well, I guess what I would suggest, Your Honor, respectfully, is that at the MDJ level, the nature of the cause of action is not specific, and although you're on notice of a claim, the logical extension to that would be, why, if that's the case, then once I file a complaint, for example, with the Court of Common Pleas, why would any claim that I want to amend that complaint to include be time barred then?
It wouldn't be. I mean, I think well, this claim in particular, I mean, let's talk about this claim in particular. What else was it that your client needed to know about the nature of the claim? The claim is for $10,000 that the plaintiff believed they were owed on a contract for a house that was never completed. I mean, what else would have had to been said?
There was never a claim made.
Pardon me?
There was never a claim made that he had stolen or converted that $10,000 until the filing of the complaint in July of 2020. More than 3 years, almost 3 years after the statute had expired for that.
Well, this sounds like a conversion claim to me. He kept money that he wasn't entitled to. I mean, what's insufficient about that?
Well,
what your client's on notice, that he kept money that he wasn't entitled to.
First of all, in this particular claim, in these particular facts, there were provisions in the contract that was drafted by plaintiff's realtor that said that this deposit was non-refundable.
I get it. That's your defense, though. That's your answer. The answer to that complaint is this was a non-refundable $10,000. That's how the pleadings would go in this case. That's what I don't understand what more your client needed to know after the filing of the complaint in the magistrate district judge. If you had gone to the magistrate district judge, the defense would have been this was non-refundable. Correct?
Yes, Your Honor.
So why is this a statute of limitations problem?
Because the claim for conversion wasn't raised within the statute.
Well, they're not required to denominate causes of action like you are in a common pleas complaint. Most of these people are pro se, so the rules contemplate that, and that's why it's just this form you fill out at the counter in MDJ court. It's in the record. I'm looking at the complaint they wrote right here. I mean, the Rule 1007 would have even allowed them to go further. It would have allowed them to add or change averments or otherwise, because, I mean, they said failed to return or deposit at 10,000. That sounds a lot like a conversion claim, even though they weren't required to plead it as such.
Well, Your Honor, I guess I would respectfully disagree. I think they were under an obligation to make those claims specifically. I understand that you don't have to do that.
Is that your argument, though? I mean, is your argument that they weren't specific enough, or isn't your argument just what the Superior Court said, that a filing of a complaint in the MDJs does not stop the statute of limitations?
Well, that's my feeling, Your Honor.
Right. I mean, but you're not talking about this like nuanced thing. Well, no, maybe it does. It does if it specifically delineates the cause of action, or it does this, or it doesn't do that.
No, I don't. I agree. I don't think it stops the. I don't think it. I think the Superior
Basically,
Court,
it's a nothing burger. If an appeal is taken, it's as if it never happened in the MDJs. That's the Superior Court's position. That's your position.
well, I think the Superior Court said that. I think the Superior Court recognized that the plaintiffs had a duty to file that complaint, that any kind of tolling of the statute would have lasted until the end of the 20-day period.
Yeah, but I'm not sure where they got that from. I mean, I don't. I mean, it's an interesting concept, but I'm not sure where they got that from.
Let me see if I understand. So I understand this. Counsel initially filed a complaint in the MDJ. Judgment was entered in their favor. You appealed that to the Court of Common Pleas on July 13, 2017, and served a notice of appeal together with the rule and the public to file a complaint within 20 days.
That's correct.
He did not.
That's correct.
And under 1037-1004, MDJ 1004 indicates in the note that upon failure to file a complaint pursuant to the rule, Rules of Civil Procedure 1037A apply, which is a burden on you. And that burden on you is to file with the prothonotary, the 21st day, a precipice entering a judgment of non-pros. That never happened, which meant your opposing counsel now has free rein to file the amended complaint, and they did. And you go to trial, again you lose, and now you want to say, oh, let's not forget the fact that I didn't do my obligation of filing the precipice for non-pros. Let's look at this by saying, oh, let's bring up the statute of limitation, that he exhausted the statute of limitation of 2 years by filing it on the 3rd year. How does that make sense?
Well, again, Your Honor, what I would say is that presumes that 1037 places a burden on me to file that precipice.
The language of 1037 does.
Why would they file the precipice?
Why do they want a non-pros? They want
No, I understand that they wouldn't file a non-pros, but what I'm saying is that that rule doesn't say that the defendant shall file a precipice.
If you want it dismissed, it does.
And it does. Let's start with all due respect. Let me read it to you. 1037, judgment upon default or admission, assessment of damages. A, if an action is not commenced by a complaint, the prothonotary, quote unquote, upon precipice of the defendant, aka you, shall enter a rule upon the plaintiff to file a complaint. If the complaint is not filed within 20 days after service, the prothonotary, upon precipice of the defendant, you, shall enter a judgment in non-process. What is it about that statute that doesn't mean the burden's on you?
It doesn't make that a necessity for me to file that precipice.
It does, but that's your argument. I got it.
That's my argument, and there's nothing in the rules that suggests that I can't make or I can't file as an affirmative defense a statute of limitations.
It does when you permit the waiver of that statute of limitation by failing to file your precipice of non-pros. Let's leave it up to see if I can convince my colleagues that you lose.
Are you aware, counsel, of any circumstance where this stop and start clock, I mean, stop and start clock that the Superior Court came up with here exist? I mean, the only thing I could imagine is somewhat analogous is Rule 600. Maybe they were thinking of Rule 600 when they invented this. I don't know. But this idea, either a complaint tolls a statute or it doesn't.
Right.
There's not like some in-between land here. I mean, do you disagree with that?
I guess what I would suggest is, in terms of a complaint filed in the District Justice Court, I would respectfully say that that doesn't toll the statute.
That what?
That does not toll the statute.
At all? So it never
So
stopped.
you're going further than the Superior. The Superior Court invented this thing where they, stopped it for a while, then it started running again, and I guess they're coming up with something new here.
Well, again, I think that the filing in the MDJ court is informal, and that notice of particular claims are not made in those complaints, and that's not sufficient to inform the defendant of the claims that the plaintiff is making. And when you get to the Court of Common Pleas, those claims have to be set out in detail. So, and I would point out,
You're taking the de novo aspect of a whole new proceeding in Common Pleas Court to mean that the whole thing starts again.
well, I think that's basically what it says. I mean, in the note under that section says the Court of Common Pleas shall treat it as if nothing was filed before the magisterial district justice. That's the note under the I think in the official note under Rule 1007B or 1007.
All right. Do any of the justices have further questions? Nope. Thank you both very much.
Thank you.
Mr. Minner, will you now adjourn court?
Court is adjourned.